Long count. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 10, 9, 8, 5, 4, 3, 2, 1. In the long count.
That was on. Start out there.
And I think we've got most of them in PowerPoint. If you want to use them, so.
I did have to take a picture on my phone. Picture down here.
Yeah.
If I have to tag all the the way I know to do it. Back in the day, we got. Longest,
Just blow up. Yeah.
poster boards.
Because I assume you probably have to get like storage units and stuff like that to store all this stuff.
Have a vault.
Good morning.
Good morning, be seated.
You know, reading something. I think it's fundamental. I just didn't say the parentheses.
She had a conference. She's in the middle. She's done. But she's on the live thing. She texted me. Said hi. I'm clearly not enough, but I'll deal with that on my own.
Can we have the defendants, please?
Your Honor, can I just have one brief indulgence to go with the lady before we start?
Yes, that's, yes.
No, no. Oh, one ten. We'll be good. Let's go with that.
We can wait till she gets back from.
They have a fit right now. It's on the table. My phone on the table.
No, it does. It's because I'm not worried about it. I'm looking forward to that. Like one of the next times I sit down will be at Russia.
They probably have.
Well,
You feeling better, Judge?
Yeah. I think I'll survive. Thank you for asking. Miss Stengel didn't care. She didn't say a thing about it.
And the
So.
only reason I
I'm
ask
so
is
worried.
Somebody's got a cold in my household every day of the week.
I'm still human.
You know, the daycare germs, they kind of.
Oh, yeah.
mutate into-
Oh, yeah.
You don't have to act like you.
Oh, cool.
My kids will get something and they'll be better in 2 days and it'll knock me out. My wife,
Oh, yeah.
2 weeks.
Oh, yeah.
Defendants get in, can we approach something?
Yes.
Oh, it wasn't just that one trial. No.
so
Look at it.
okay. There was a few additional things in the changes that we wanted to make sure of. What we wanted, some extra
Should we be on the
parentheticals.
record?
No, she's just letting us
Yeah,
know.
some extra parentheticals and stuff that we hadn't decided for sure. So the colored ones have highlights with what it was originally. And then the black ones are changes that Judge made. And we're just gonna go through and make sure everything's tweaked as everyone wants it before the final is printed.
Is there an electronic version? No, okay.
Well, I can send you
I
the
don't want,
electronic.
if it takes time, I don't want to do
No,
it.
no,
Okay.
I have to.
Yeah.
And we do, there's only one per table just because of.
That's, there's a lot of paper, yeah. You're totally fine.
You know, I like to see trees. I did. See it.
Just making sure.
How that works?
No. You're still going, maybe.
I'm just here for moral support at this point. See, I normally do the law. Sometimes that's more. I was actually talking about this morning. I was like, I'm gonna go back.
Slow boil.
15 years.
If I were still needing to further my application, would actually do last year. I'm being that serious.
That's actually that's the nicest thing I think you've ever said.
That's the bar that we need to have.
Exactly.
Unrelated, you said Sam has read the Procedural series, right? Actor, and Hawthorne Rose.
Yeah, I'm actually.
The 6th book is coming out in October. Just make sure.
I think we're waiting.
Dixon, did you still want?
Yes, if we can, they're not in here, but if we can approach, I guess, without them.
No, probably not for this. This is kind of, I guess, court management type issue. We just have like a court management issue we wanted to address for the court.
Oh, yeah.
Yeah, your client shouldn't have to do this.
Yeah, I heard you say.
Yes.
You ready for the,
For the defendants? Yes.
I feel like I got someone more wiser than me, Vaughn, said, hey, you need to take this right here. It was, I believe, D. And a lot drier.
I'll bring it, well, we can.
That's next week. That's the 13th.
It's mandatory.
All right. We are on the record in the case of State versus Leon Tripp and Tanya Tripp. Indictment number 2023 RCCR 01585. Defendants are present in courtroom of counsel. Good morning, Mr. Tripp. Good morning, Mrs. Tripp. Before we get started, just want to alert the audience that there will be no video, audio, any type of recording of this proceeding in this courtroom. Absolutely none whatsoever. We find out that somebody is recording these proceedings in this courtroom, videoing, audio, any kind of recording, post it to the internet, that person's gonna have a problem. So, please govern yourselves accordingly. All right, I looked at the issue of impeachment regarding the defendants not actually taking the stand, and I have reached the opinion that unless you are a sworn witness, you can't be impeached. I think the case law is pretty clear on that you have to be sworn. I know there was something else I looked at, but we had a long, Miss Sham and I had a long night. She was on her computer doing things related to the charge, and I was responding to them early this morning. So I hope this is the latest draft that I did this morning. But if you will look at your 2 copies of the charge, and I think if you go to page 3, presumption of innocence, and you see the highlighted portion, and you will see that I have removed the highlighted portion on that, and want to find out the feelings regarding my removing that part of the charge.
And Judge, no objection. The only caveat to that is, in previous hearings, previous discussions, there's been some,
I understand.
in reference to Mr. Tripp.
Right.
This language doesn't specifically go to that, but I just wanted the court to be aware.
And if y'all believe it should be necessary, we can.
I don't believe so, Judge, but I just did want to put that on the record.
Ms. Stengel, Ms. Barnum?
I don't think it's going to be necessary.
Okay. Mr. Rakes?
I'm in accord.
All right, so 3 that will be the charge in 3. On page 3, I'm to be accurate. So I think page 13. And I'm sorry, page 13 is the highlighted portion. Accomplice corroboration. Let's see. And it's page 12 on the unhighlighted. And you will see that the first sentence, I removed it because the charges, in this case, there's no exception to the rule regarding corroboration. I think perjury and treason, I think, are the rule exception. That will require Unless there's disagreement,
I have no objection to that, Judge.
No objection, sir.
No objection, Your Honor.
all right?
So it's okay if we sit while we do this.
Oh, absolutely.
Thank you.
And then you see the parenthetical below. I didn't think that was necessary to have in the charge. Those 93, 94 will come below, but
Yes, Judge, as long as we're giving, 93 and 94.
yes, they follow.
No objection to that.
No objection.
All right.
No objection, Your Honor.
All right, thank you very much. But I'm not married to any of this, so if anybody got a problem, don't, you know, I'm not offended by any changes that council believe is necessary. Page 18 on the highlighted version, I didn't think that this was applicable to our situation. I don't think we had any conditional evidence admitted until there was some other subsequent basis for it being admitted. I think all the evidence either was objected to and it didn't come in, or came in anyway, or it came in. I don't think we had to condition the admission of any evidence.
And Judge, I think this was one of the ones that the state had requested. We can withdraw that.
I mean, if you think it is,
I mean, no.
we
Judge.
can definitely put it in there.
No, we can, I'm fine. I'll withdraw it on behalf of the state. If they still want it, I'm not going to have any objection to that.
Ms. Barnum?
That's fine, just.
I mean, Mr. Regis?
I have no objection to the state's withdrawal, Your Honor.
All right, so that one is out. Page 20, that is. Just council's feeling as to the highlighted portions. I removed, maybe as I'm about to discuss. I mean, if you want it there, I can put it back.
I think the language in this version, where it says, as discussed below, if applicable, I think that's fine.
Ms. Barnum? I don't think it really that big of a deal. I don't know. I think last night I thought it was. I don't know why.
Yeah, I think that that's fine too.
But it's easy to put it back if you want it.
I don't think it's necessary.
All
No
right.
objection to its removal.
All right. Thank you, Mr. Regis. And the next page, under circumstances of the statement, illegal detention. I kept it in there, all that language in the charge, but I wanted to know the feelings of council.
I'll defer to defense counsel on all of the voluntariness stuff. If they want it, that's fine. If they don't want it, that's fine.
I'll defer as well, Your Honor.
Judge, to be clear, are we saying that everything, including the highlighted portion, will be in?
Everything is in.
Because I don't think the highlighted portions are strictly necessary, but
Well-
we'll defer to those.
Well, I mean, as I said, I mean, if, I don't have any problem changing it if there is no objection to it.
And again, Judge, when it comes to all of the voluntariness stuff, the constitutional stuff, I'm going to defer to defense counsel, so you can, they want it, that's fine. They don't want it, that's fine.
Mr. Regis, are you deferring to?
I am, Your Honor. I think that's more that's their issue, it's not ours.
Okay,
We'd like for it to be included, Judge. Thank you.
all right, so you like the highlighted to be included?
Everything, yes, sir.
All right, well, I think I have it, so, okay.
That's correct, Judge.
All right. Page 23 on the highlighted copy. 22 on the unhighlighted. I, of course, said would be a part of the charge, wrote or signed. I don't think there's anything written, so I think that would be out. But I understand that the defendant signed a waiver. Does the defense want that included in the charge?
I don't see the need for wrote and signed. I'd be content with it stopping at said.
Ms. Burnham?
That's all right with us, Judge. Thank you.
All right, so, wrote and said, I'm sorry, Mr. Regis, you said you keep wrote and said in, take wrote and sign out.
That's correct.
Okay, all right. Any objection from the state?
I'm not gonna have any objections to what they want on these next few, Judge.
Yes, sir. All right, 24, page 24, that is, and you see the highlighted, except for the purpose of attacking the witness's credibility, impeachment. And as I said, I don't believe impeachment, as far as the defendants are concerned, is applicable. And I removed that language from the charge.
We agree, thank you.
All right, Mr. Regis?
I agree.
No objection.
All right, so that will stand. '28 on the highlighted copy. That charge will be determined, according to the state, after argument.
I believe so. I mean, not to kind of call Mr. Regis out, but his opening statement is lies, love, and Leon. If that's the general argument, I think that would probably be applicable in this case, but obviously I haven't heard his closing argument.
That will be the argument, and I don't see the applicability. Or that will likely be the argument, I never fully know.
I would just say we wait until we hear the arguments, and then if,
Okay, well, that's what we had agreed on earlier, so that's why it is still highlighted so that we know that it is, at the present time, not a part of the charge. But it may become a part of the charge. Page 30 highlighted. I think that is just where we tried to make the language just agree with the charge because we're dealing with several defendants. I don't believe it had anything to do with really changing the substance of that charge.
that's fine.
Ms. Burnham?
Fine with us, Judge, thank you.
Mr. Regis?
No objection.
All right, thank you very much. Page 37, that is. Page 36, on the unhighlighted version. I left that language in. Is there any objection to that, of the highlighted language?
I'd ask it be removed, Your Honor.
Okay.
I think it's sufficient without it. Nor did I hear evidence in support of it.
State?
One moment, Judge. Well, Judge, I think since the court has decided to give the conspiracy charges, the language of it, I think that's kind of necessary in this charge.
Ms. Burnham?
I missed it. I didn't hear what the court indicated it had decided to give the conspiracy, I guess.
I think we got an email last night
Oh.
that said that the court had decided to give the conspiracy charges. I may be mistaken, but
I believe that's right.
I don't,
I didn't see it until this morning either, so.
did I? I don't, huh?
It was late.
I did?
I did.
You said it? Oh, okay. All right, well. So, yes, I did inform my staff attorney that I was going to give the conspiracy charge, so I believe it would be appropriate to include this language in light of the fact that I am.
And I'm in agreement, Judge.
And I'm taking that, Mr. Regis, you're accepting?
Yes, to the charge of conspiracy as well as this included language, Your Honor.
All right, and I would imagine that Mr. Tripp would also adopt that exception. All right, noted, and of course, we would also need to make it again at the appropriate time. Page 45. I didn't think any of those defenses were raised in the highlighted portion.
I agree, Your Honor.
I agree, Judge.
Agree.
So it would end with rather it is the unlawful intent to kill. Everyone in agreement on that?
Yes, okay.
All
Yes,
right.
Your Honor.
Excuse me. And I believe the last thing, page 60, I believe that all the parties want this to be included in the charge that, to the jury.
Yes, Judge, and I will state, again, the only reason I kind of included that, I have seen judges give this verbatim. Some judges have their own style, but I think the general gist is just to give the jury some instructions on when they're back there, that they need to communicate with.
I'm just gonna read it as written unless there's objection.
I've never seen it before, but I have no objection to it.
No objections, I think.
All right. And of course, we'll handle the alternates and let them know they don't go out to deliberate unless needed. Didn't bring down a verdict form, you did? Huh?
Right now.
Okay. So we'll have a verdict form unless someone has one that they think might be better.
I assume that we'll have a break in between
Yes.
some of the closing arguments. I can propose one to the court if they wish, and show
I
it again.
got a former Judge Craig verdict form that I like, you know, but, so we'll bring it down. You want one, then we can,
Saves me from having to do it, so I'm fine with that.
all right. So we'll have that. All right. Okay. Y'all worked us last night, I can tell you that. Anything further regarding instructions?
Not on behalf of the state, but
Is the state going to open and close or just close?
Opening close.
Okay. All right. Do we need any time for you to set up anything? Ms.
I can do that now.
Okay. All right. Before you do that, anything else? I think we're good on the charges there. Anything else? Any other matter we need to address before we bring the jury in and?
I don't believe so, Judge.
Okay. Does anyone need a break? Okay. All right, and, okay. All right, so staff attorney said she's gonna make sure that she emails everyone the electronic copy of the charge also. Excuse me? All right.
I did that.
So is there any objection to the written charge going out with the jury?
No objection on that.
No objections.
Mr. Riggins? All right. All right, with that, we're ready for the jury.
All rise for jury, please.
Be seated, please. Good morning, ladies and gentlemen. Starting a little later, there was just some matters that the court had to take up as required with the attorneys. That has been done. We have come to the stage of the trial in which now the attorneys for each party has the opportunity to make a closing argument to you, to persuade you to one side or the other. The state has the option of giving an opening, and they also have the right to have the concluding argument. And at this time, the state is going to make an opening argument. Ms. Dixon?
Please, the court.
Yes, ma'am.
Ladies and gentlemen of the jury, good morning. Good morning. And this might be the last time that I say good morning to you. As the judge says, the state, we have the burden to prove this case. So we get to go first, and then we get to go last. So what's going to happen is I'm going to talk to you. Then Ms. Stengel is going to talk to you regarding Leon Tripp. And then after that, Mr. Regis is going to talk regarding Tanya Tripp. So by the time it gets back to me, it might be in the afternoon. So when I come back up, I might be saying, good afternoon, ladies and gentlemen of the jury. Now, what I like to do at this part in we call this an opening close, is I like to give you a roadmap about where we're going to go. So I just told you what's going to happen after I sit down. They're going to talk to you for a while. And then after you've heard all of the opening statements, all of the closing statements in this case, the judge is going to give you the judge's charges. And that's going to be him reading over the law that you need to follow while you deliberate on this case. And before I get to that, I want to talk to you about the duty you have as a juror. Now, if you remember in voir dire, one of the things we asked is that everybody can be fair to the state as well as to Mrs. Tripp and to Mr. Tripp. So I want to talk to you about the juror's duty. What are y'all here for? You are here to search for the truth. And that's what we want you to do. Search for the truth. Look at the evidence in this case. What really happened based on the evidence? Apply the law to the facts. Again, we talked about it in voir dire. You have a duty to follow the law. You are bound by the instructions and the law given to you by the judge. You're not to become an advocate for one side or the other. Again, you're to be fair and impartial when you start your deliberations towards both sides. Now, sometimes this happens. A couple of months ago, I had a case, the jurors went back to deliberate. They were there quite some time. And if this happens after a while, the judge calls you back in. You might say, hey, we're deadlocked. And the judge is basically going to tell you to go back and keep deliberating. Well, what happened in this case was it went on into the next day. However, one of the jurors did not come back. Well, she didn't come back, an alternate got on, and then shortly after that, they reached a verdict. Now, after cases, sometimes we talk to jurors, and what we found out was that there was a juror who just did not want to deliberate. Everybody felt one way, this juror felt another way, just didn't want to deliberate, kind of went, locked themselves in the bathroom. So if something like that happens, you can bring that to the attention of the judge. Everybody has to deliberate. Again, we have to be fair, we have to look at the evidence in this case. Again, your duty as a juror is to think about what is inside of the circle, not what is outside of this circle. What is inside of the circle is the evidence that came from that chair, from those slides, from things that we put on that screen. What you should not consider is, again, what's outside. So passion, don't consider passion. Public attention. No, this is a very well publicized case. You can't consider public opinion when you go in that jury room. Dislike of the police. We had some jurors, we asked the question in voir dire, do you dislike the police? Do you dislike my office? Again, you don't bring that into the circle. Sentiment. We're leaving sentiment at the door. Sympathy for the defendants, you leave that at the door too. Now, if you disagree with the law, you still have to follow it. Remember, you took that oath to follow the law. So maybe you don't like some of the laws that we're going to talk about in a minute, but again, you have to follow the law. Conjecture. Don't bring conjecture into the room. Don't bring prejudice into the room. And don't bring penalty and punishment into the room. At the end of the case, you're going to be given a verdict form. And what that verdict form says is either guilty or not guilty. You're not to consider the punishment of the defendant in this case, defendants. What can you consider? The elements of the crime, and we're going to talk about that in a second. The law, and again, the judge is going to talk to y'all for probably about 45 minutes when everyone's done closing, and he's going to go over the law that you can consider in this case. Expert testimony. We had a lot of experts in this case. You can consider their expert testimony. You can consider their credentials. You can consider what they say. Photos and documents. Lots of pictures in this case. You can consider those. Consider the photos. Consider photos of the burial dig. Consider some of the interviews that you watched. Consider some of the documents that you saw. The CAD, as we call it, which shows when the 911 call came in. Testimony of the witnesses. I think we had about 25 witnesses or so. You can consider the testimony of each and every one of those witnesses. The credibility of the witnesses. What motivations do they have? Does anyone have a motivation to come in here and lie? You can look at their credibility. You can look at how they testified. So again, this is in the circle, the credibility of the witnesses. The defendant's actions. Consider the defendant's actions from the time this case first started, the early morning hours of Janelle Carswell's birthday. And we're going to talk a little bit more about that when I come back up, but you can consider the defendant's actions. What is the defense? You can consider the defense in the case as well. That's inside the circle. Fleeing. Consider fleeing. And of course, and this is a case really about common sense. You can consider common sense in this case. You can use your own common sense in this case. You can use that common sense to apply it to the evidence in this case and to the witnesses in this case. Now, the evidence. Outside of what you heard on the witness stand, there are a lot of interviews in this case. 911 call, body camera. We call that kind of hard evidence. Now, a lot of times people don't realize this when they go to the back, you're not going to have those things with you when you go back to deliberate. So, you're not going to have the 911 call, you're not going to have the body camera, you're not going to have any type of visual medium that you guys can go back there and watch. Does that mean that you can't watch it? No, not at all. If you want to see any of the evidence in this case, you can write a note to the judge. You can say, hey, we want to see that body camera from April 17th. That's the body camera where Deputy Cook came and spoke to Ms. Tanya on the first time. You can ask to see any of that. And how that happens is you write a note, you guys are going to come back into the jury box, we're going to queue it up for you to watch, and you decide what portions you want to watch or how you want to watch it. So again, it's not going to be back with you, but it's available to you if you want to watch it. And what is this evidence? Again, it's the 911 call from April 17th. It's the body camera from April 17th. It's all of Tanya's interviews. That one that she had with Detective Madden on May 1st, there's no video on that one. That one was audio. There's the interview she did with Renetta Du Bois. There's the interview she did with Pastor Hardin. There's the interview she did when she was in custody with Agent Wright of the FBI as well as Investigator Dobbins. There was the other one on May 30th. Additionally, there's evidence regarding Mr. Leon Tripp's interviews, and you can ask to see these as well. Now for Mr. Tripp, we have that first one on May 23rd at the DeKalb County Jail. I like to call that one the Denzel Washington one. There's no video on that one, but there's audio on that, and you can listen to that one. Then there's the June 2nd one. That was with several interviewers who came in and talked to Mr. Tripp. And then there was the June 9th one where we had Sheriff Roundtree as well as Investigator Lucas Grant, who testified yesterday. Then we have that body camera from March 8th. That's the body camera where they discover where Janelle Carswell finally is after about a year. And you can watch that body camera where you see that deputy take that shovel and then he hits on, he says, it's a human skull. Let's get out of here. You can watch that one again. And then also cell phone records. Now, legal concepts that I want to hit on. I was on a jury before I went to law school, and again, after these closings, the judge read us a bunch of law. We got to the back, and we were like, what did that even mean? So I decided, and I wanted to go to law school, I decided, okay, if I'm an attorney, I'm going to try and tell them a little bit better about these instructions, because to me, and I was real young, to me it was like Chinese. It was a foreign language. I did not understand what the judge was saying. And what I felt made it worse is when we had a question, we came back out, and he just read the thing over again. There was no explanation. So we were like, we don't understand reasonable doubt. So we came out, and he read reasonable doubt that he'd already read 30 minutes before. So I think it's a little confusing, so I like to go over these concepts at this point. Now, the first thing I'm going to start with is reasonable doubt. Reasonable doubt is the doubt of a fair-minded juror, honestly seeking the truth, an impartial juror. We're not seeking doubt, and it's not beyond all doubt or mathematical certainty. It's where you can state a reason, a plausible reason, not maybe Martians came and buried this girl in the ground around the corner from her house. A reason, a plausible reason. Now, the next concept is venue. Now, I think we asked one or two witnesses, where was Janelle's remains found? They were in Richmond County. Now, for every homicide case, for every case, every criminal case, the state, we have to prove that the venue, we call, is in Richmond County, and that means that the crime happened in Richmond County. Now, I'm going to get into where I believe the crime happened when I come back to you. But what we know for sure is that she's buried in Richmond County. And that's what this slide is talking about. That second paragraph, if a dead body is discovered in this state, and that's what we have here. We have beyond a dead body, we have skeletal remains But Jamel's skeletal remains were found in this county. And if the county where the death was caused cannot be considered, it shall be considered that the cause of death was inflicted in the county where the dead body was discovered. So what does that mean? It means what I just said. Her skeletal remains were found in the woods behind 2211 Golden Camp Road in Augusta, Georgia on March 8th, 2018. So since her remains were found there, that means that we have venue in Richmond County. Now, Mr. Mullis came to you in opening statement, and he talked about parties to a crime. And I'm probably going to talk to you about this almost a little bit more than you probably want to hear. But again, when I started practicing, it was just a hard concept for me to understand. So I like to go over this a lot to make sure everybody is crystal clear on what it means. A person is a party to a crime if that person directly commits the crime, or intentionally helps in the commission of the crime, or intentionally advises, encourages, hires, counsels, or procures another to commit the crime. Now, I want to give you some real-world examples. And again, as a young person, this kind of blew my mind. But do you think that everyone involved, from the person who actually commits the crime, to someone who helps with the crime, to someone who encourages or enlists others to commit the crime, should all be responsible? So whether you're the one committing it, or let's go back to my example of me strangling Mr. Mullis. Let's say that somebody asked me to strangle Mr. Mullis. Somebody encourages me to do it, and I go ahead and I do it in this courtroom. Now, I'm responsible because I did it, but again, the person who asked me to do it, they're equally as responsible. Again, the law does. And if you disagree with the law, we need to check that, because what the law says is that everybody is equal. Here's a real-world example. 4 men drive to a bank to commit a bank robbery. You've got the driver. He never gets out of the car. You've got the lookout. He stands outside. You have a man without a gun inside a bank. He's in the bank. He's part of it. He doesn't have a gun. And then you have the man who goes in the bank, and he shoots the guard. Who's guilty? Under the law, all of them are responsible. They're all responsible for aggravated assault and armed robbery. But only one man had his finger on the trigger. Only one man really actually shot him. But again, under the law, and that's what we're following here, it's as if they were all holding that gun together. The law does not distinguish. That's what parties to a crime means. You're all in this together. Gold star. Gold star means let's note on it. All who are involved, all are involved, so it does not matter who actually had the gun in their hand. Under the law, the other people helped, okay, or they encouraged, and that helping made the crime possible. That helping made the crime possible. So all of them are guilty. And under the law, you can consider before, during, or after the crime happened. Look at that behavior. Again, before, during, and after. The other people helped so that the crime could happen, so they are all guilty. Now, I want to talk to you about the concept of conspiracy. A conspiracy is an agreement. You can have it express. That means they agree out loud or in writing. You can have a conspiracy implied. Both know what they are going to do without any spoken word. So you know you're both in it. You know you both got skin in it. You know you both have something to lose in it. So that's a conspiracy. It has to be 2 or more persons, and it's going to do an unlawful act. That's what we have here. We have a conspiracy between husband and wife till death do us part, for better or worse. We have a conspiracy because we both got skin in it, really. Now, what's the proof? Look at what they did, how they did it, what was said, all the circumstances around the crime. And we'll talk about that when I come back. But hopefully the wheels in your heads are already turning, thinking about all the evidence and all the ways that they were helping each other from the very beginning of this incident. So, any act done by Leon Tripp or Tanya Tripp to further the unlawful enterprise is considered to be the act of all of the co-conspirators. Both of them. Both of them. You can also consider the credibility of the witnesses. It's for you to determine who you believe, who you don't. You can look at their motives. You can look at how they testified. You can consider their personal credibility as you observed it in court or on video and by the evidence that corroborates their testimony. What was their demeanor? What facts did they testify to? And has anything been proven as a lie? And sometimes you have conflicts in testimony. And how do you decide what to believe? You look at the evidence. The only one I can really think about in this case is Agent Wright, FBI agent. He says when he called her, she basically hung up the phone. She said, "My daughter's not missing." Hung up the phone. Ms. Tripp says, "No, I didn't hear that. I don't think that's how it really happened." But again, look at the evidence. Look at what motivation does he have to come and say that? What motivation did she have to say that back in 2017? So, if there's any other conflicts in the testimony or in the evidence that I didn't notice, think about it. Think about the motivations. Confessions. Or statements, rather. I think we have confessions in here, we have statements. But we have some pretty bad statements in this case. But the state has to prove to you that the statements that were given were freely and willingly given. And that means without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises or rewards. Now, back in the day, people were beaten until they confessed to something. People might have been coerced, they might have been forced. You've seen the interviews. That didn't happen in this case. I asked every officer who interviewed one of these two, were they forced? Were they promised anything? Was there any leniency? And they said no. And you saw them go over the Miranda forms. Every interview. When they were in custody, they went over the Miranda forms with them. And then at the end, they waved and they said, yes, law enforcement officer, I will talk to you about this. Now, counsel's been great in this, and Mr. Regis may or may not make a big deal about the fact that on one of the forms, it's blank. One of those Miranda forms. But Investigator Dobbins told you about that. He said, and you saw in the video, she had one, I had one. She signed hers, you see it's her signing on the video, and this is the copy that he had. But again, it's on the video that they went over those forms with them, and they waived their rights, and they spoke to law enforcement. Now at the bottom there, we also have to prove the defendant was advised of her constitutional rights, and they clearly understood and knowingly gave up such rights. I believe we've proved that on all of these interviews. Now, if a defendant exercises his rights, one of those rights is to have an attorney present. So if the defendant, and Mr. Tripp did, on that June 9th, he said, hey, I want my attorney present. So what does that mean? It means exactly what Lucas Grant did. He stopped the interview. He stated he called the district attorney at that time, Ms. Payne. Ms. Payne called Mr. Tripp's attorney, Peter Johnson. Peter Johnson was on his way over, and Lucas Grant went in, to talk to Mr. Tripp. And as he went in there, Mr. Tripp started talking to him and saying some incriminating things. Now, that's where this paragraph comes into play. If the defendant, solely on his initiative, after exercising such rights, freely and voluntarily requests and initiates further conversation with the police without an attorney and without any request, instigation, coercion, duress, fear, or hope of benefit, then you would be authorized to consider it. So again, Investigator Grant's actually about to step out of the room, and Mr. Tripp starts talking to him. And then the sheriff and Peter Johnson, his attorney, come in there, and he tells him what he tells him. I'm tired. I'm ready to end all this. I'll tell you where she's at. Direct and circumstantial evidence. And again, Mr. Mullis did a great job telling y'all about this when we first started. Direct evidence is evidence that you can hear, you can sense, you can smell, you can touch, you can taste it. So the exhibits, the ring, for example, that's direct evidence. That's the ring that Shadera Carswell gave to her niece. And Alice Gooding told you where that ring was found. Still on Janelle's own hand. But that's an example of direct evidence. Testimony is direct evidence. Any evidence specifically about the guilt of the defendants. So like we said in opening statements, we don't have this crime on video. We don't have an eyewitness to this crime. This is a crime that we get to the answers from circumstantial evidence. Now, I want to give you some real-world applications of what circumstantial evidence is. So, we've been here for a long time, and for me, the days are running together, but I get here pretty early in the mornings in order to get ready for this trial, and I leave pretty late at night. So one day, I come in, and then as people are coming into the office after me, they have umbrellas that are dripping wet. Now, I didn't see rain because I'm in the courtroom and there's no windows in here. But again, I'm using circumstantial evidence to make the deduction of the fact that it was raining outside. People have umbrellas. So that's circumstantial evidence. Now the other one, if those of you who have kids or you're around kids, maybe you have toddlers, you bake some cookies. Put the cookies on the counter. You're letting them cool. You step outside the kitchen. When you come back in the kitchen, your 3-year-old has kind of dirty hands. And he's really happy. And he's doing this. And the cookies are gone. Okay. You didn't see who ate the cookies. You didn't see what happened. But you know that your child ate the cookie. And that's circumstantial evidence. And that's what this case is. We know who ate the cookies in this case. It's the defendants. The charges. Mr. and Mrs. Tripp are charged with 4 charges in this indictment. Now, you don't have to write this down because you will have a copy of the indictment when you go into your deliberations. But there are 4 charges. I suggest you start with the bottom and you work your way up. It's just easier that way. Number 4 is concealing the death of another. And you will see that charge listed in the indictment. And it says between the 17th day of April 2017 and the 23rd day of May 2017, the exact date being unknown. And we picked those dates because, again, nobody saw from Janelle after the 17th, and then on the 23rd, that was the day that Mr. and Mrs. Tripp were arrested. But it states that they did bury LaTanya Janelle Carswell, and they provided false information to law enforcement regarding the whereabouts of the victim. And this is another confusing concept. It says and, but and also means and or. But again, that's what that count 4 is. Gave bad information, and then they buried that child on her 16th birthday. The next count is aggravated assault. And that count says that they made an assault on the person of Latanya Janelle Carswell with an unknown object, which when used offensively against a person is likely to result in serious bodily injury. We don't know what that object is. We don't know. So we told you in opening. I know what I think it is. And I'm going to talk with you when we come back up here. But we don't know. Because they buried her, and by the time she was found, she was bones. And that's what the doctors told you. So we don't know what actually made the assault on Janelle Carswell. The next count is felony murder. Felony murder is an intent to harm, but somebody dies during a felony. So it's maybe not like the intent to actually murder. If we go back to that bank robbery example, we can kind of stretch it out. So in the first example, somebody shot the clerk. In this example, they shoot the clerk and the clerk dies. He didn't mean to shoot the clerk, he just wanted to rob somebody. Okay? So maybe in this case, didn't mean to kill Janelle, just wanted to get her under control, hold her around her neck. So it's an intent to harm, but not to murder. But if somebody dies during that felony, it is felony murder. The first part is malice murder. And this means an intent to kill. What is malice murder besides an intent to kill? It's the unlawful killing of somebody with malice. Juries get hung up on that with malice part. What does malice mean? It's legal malice. It's not ill will or hatred. It's legal malice. Again, it's the unlawful intention to kill. You can have express malice and you can have implied malice. Express is just where you deliberately kill somebody. It's just, again, my example with Mr. Mullis, if I intentionally kill him. Implied malice, it's unprovoked. You look at the circumstances of the killing, and does it show an abandoned and malignant heart? Lawyers, right? What does abandoned and malignant heart mean? An abandoned and a malignant heart means you just don't care about the consequences. It's a reckless disregard for human life, and it constitutes implied malice for murder. And I can't think of anything that is more of a reckless disregard for human life than burying a child in a shallow grave and letting her rot. Now, I've come to the end of what I call my opening close. I'll be back in a little bit to go over some of those points that I had highlighted. But before I do, I did want to just take this time to, again, recognize the individuals who are here at this table with me. And that's Mr. Mullis, and I'm sure you're wondering, but this is our paralegal, Brittany Hurd, and she's been my assistant during this case. But again, in a little bit, it will probably be afternoon by then, I will come back and I will give you the rest of the state's closing argument. Thank you.
Ms. Stengel, on behalf of Mr. Tripp.
Yes, Your Honor. May it please the court.
Yes, ma'am.
Good morning, everybody. Leon Tripp is not a murderer. Leon Tripp is not a mastermind. Leon Tripp is a man with an 8th grade education who's not very good at technology, who is in a marriage with a controlling woman who lied to both him and the community before and after their daughter disappeared.
And we heard about her being controlling. I mean, even in Tanya Tripp's own words, she said a few times, when I call them, they answer. When she was talking about the night of Easter, when she called Leon to come home, she said it took him 6 minutes. I timed it. We also heard from Leon that sometimes Tanya wouldn't let him leave. But what we also know is that Leon was the only one bringing in income to this family. And we heard him in a statement talk about the fact their bills weren't getting paid. Their water was getting shut off, and they were headed to an eviction, which we know eventually did happen. Leon was not the one controlling the narrative of this story. Leon was doing what he has always done in trying to provide and protect his family and his wife, who he believed was pregnant with his child and had cancer. Now, Tanya Tripp's attorney, in opening statement, made a big deal out of love, lies, and Leon. And while that's catchy, I think after we've heard the evidence and we've heard from witnesses, it's clear that the biggest liar throughout all of this, telling the most lies, was Tanya Tripp. Leon Tripp is not a murderer, and Leon Tripp is not a mastermind. And I'll take you back to opening statements. You heard from my co-counsel, Ms. Burnham, and she asked you to consider 3 things while you were listening to the evidence. Who's telling the story? What does it prove? And is it good enough? So let's talk about who's telling the story, right? And as the state even put up on their PowerPoint, we start with Belinda Bunch. She was the one who allowed us to play the 911 call made by Tanya Tripp, the initial 911 call about a missing person. And that's where we first hear this story about Leon Tripp taking Janelle to go help Maurice in Clarks Hill. Now, we also heard from David Milford. He was the IT guy for Richmond County Sheriff's Office. And he really got on the stand so that we could actually look at Deputy Cook's body camera. Now, Deputy Cook responded to that initial missing persons report, and he interviewed Tanya in her living room. We watched it. And in that case, again, it's Tanya Tripp telling the story that Leon went to Clarks Hill. And in that video, we also see that it's Tanya Tripp who is providing to law enforcement whose number belongs to who. She's saying, this number is Leon's, this number's Janelle, this number's mine. She is the sole person providing that information. And then we move on to Renetta Dubose. She had interviews with Tanya Tripp, I believe at least 3 times. She had a platform, and on that platform, Tanya Tripp talked about her treatments with cancer. And again, continued to tell the story about Clarks Hill. We also heard from Ernestine McKee. That was the woman who knew Tanya from church, who also confirmed Tanya had told her about her cancer and her pregnancy. And actually on the day of April 17th, Tanya went over to Ms. McKee's home and told her again that story about Clarks Hill. And while she was telling this to Ms. McKee pointed out that she didn't cry at all, and she didn't appear like she was grieving. We move on now to Pastor Angela Hardin, who we know also had a platform. She had a radio show, she has a following on social media, she still does. Tanya Tripp did multiple interviews with her, again, telling the story about Clarks Hill, controlling the narrative. She is the only person we have heard from throughout this investigation so far. She is the only one putting out this story. We also know, again, Investigator Sylvester. He spoke with Tanya Tripp multiple times. And she lied to him. She called him. She would call him for information. Right up until the very day she was found with Leon Tripp at the U-Haul station. She called that morning to ask for more information and to reiterate she has not had contact with Leon and does not know where he is. That very day, she is found with him. And Investigator Sylvester also confirms that throughout this investigation, Tanya Tripp is the one who has provided them with the information about the phone numbers and who they were associated with. And again, I know it feels like I'm saying the same thing because I kind of am. Lieutenant Madden also did an interview with Ms. Tanya Tripp in her living room. Same Clarks Hill stories being told. And we heard it so many times from her, it also honestly started to sound like a script. And lastly, we get to Mark Dobbins. Very, very straightforward sergeant, in my opinion. And when he interviewed Tanya Tripp, she told him again about her cancer and her pregnancy. And she even says a few times in that interview, I believe, "I don't want to lie." And yet, she continues to do so. And it's not just a simple lie, right? She's not just saying, "Oh, I was pregnant and I miscarried." No, that turned into, I actually went to Walmart to buy a pregnancy test. And actually then I went and made an appointment to verify that. And even so far as at that appointment, I had my WellCare card and my ID. And when it came to the cancer, she told Sergeant Dobbins it wasn't just, "Oh, I have third stage brain cancer." No, it was this started as migraines. And then I got an x-ray. And then I got a CAT scan. And then I got an MRI. And as we see, these are all things that Dobbins calls her out on. But the point is that these aren't just simple lies. They're intricate. She builds on them. It's almost as though she's been telling these stories before to other people. And when she is confronted by Sergeant Dobbins that the story about Leon going to Clarks Hill is impossible, she says, "Well, Leon lied to me." Again, who is telling the story? Tanya Tripp is telling the story. And that brings us then to what does that actually prove? What has the state actually proven to you? Well, we know Tanya Tripp lied, and we know Leon Tripp lied as well. We're not here to stand up here and say Leon Tripp was completely truthful this whole time. They both lied. But what it doesn't prove is why, who necessarily came up with this story, what details of it. You can speculate, but speculation is not proof beyond a reasonable doubt. And like I mentioned, not only did Tanya Tripp lie more often, but it was proactive. Again, she was reaching out to investigators about this case. She was reaching out to people in the community who she knew had a platform so she could get out there and spread this narrative. We also know that Leon Tripp was acting normal on the day of Easter. We heard from Willie. He spent all day with Leon, from the morning up until pretty much almost to midnight. I think he brought him home around 11:40. And he had told you, Leon had been acting normal the entire day. And he had even been at the Tate Road residence, where he saw Janelle and Tanijah playing with the dog, acting normal. We even heard from Maurice Jackson, who, while he did say, "No, I never called Leon to come to Clarks Hill, that's not true," he also said the day Leon did come to his house on Easter for that party, he was acting normal. He was drinking, having a good time, but he wasn't acting out. He'd never seen him act out. And something small, it may seem small, but I think worth pointing out, is that in several of Tanya Tripp's stories, there's a version where she pretty much says she laid down, she didn't feel well at the cookout. And she says she laid down that entire day up until she realized Leon still wasn't home, and so she called him. But Maurice Jackson told you, well, Leon, after the cookout, was at his place for the party, they wanted moonshine. And so Tanya Tripp got in her car, came over to Maurice's, and dropped off moonshine. Maurice said that was the first time he'd ever met her. What we've also learned, and what has been proven, is that unlike Tanya Tripp, who had largely appeared to be despondent in interviews, Leon Tripp did have an understandably emotional reaction at times. And that gets us to Investigator Smith. Now, Investigator Lance Smith, I believe when I asked about him, Sergeant Dobbins referred to it as a form of theatrics. Each investigator sort of has their own specialty. And I appreciated that, because we got to see that Investigator Smith's specialty is to badger a man who has just learned that his wife has lied to him about having cancer and being pregnant. Investigator Smith's specialty is to continue to try to provoke a man, again with an 8th grade education, who has been sitting for about 4 hours in an interview with multiple different investigators coming in and out. Investigator Smith's specialty was straight up telling Leon that he killed his daughter. And we saw Leon's reaction to that. Even Investigator Smith described it as explosive. And that was a real reaction and a reasonable one given the situation. At that point, Leon Tripp is backed up literally into the corner of an interrogation room. And when I asked Investigator Smith about it, if he was scared, he laughed. He thought it was funny. The first thing he did was he laughed. He said he wasn't scared. And he laughed because he knew he got the reaction that he wanted. Now, what we also know is there's a truck found. A lot of talk about the truck. But what I can dial that down to, what we know, is that Lieutenant Madden, who found the truck, who came to the side of the truck, he said there was nothing suspicious in or around the truck at the time. And then when we get to Sergeant Newsom, who actually processed the truck, again, a lot of questions for him, a lot of talk about things, but what we do know is that Leon Tripp's fingerprints were found in Leon Tripp's truck. There was no blood. There was nothing that was deemed necessary to send off to the crime lab. And there were some miscellaneous tools and shovels in the back. That's all we got from him. Now, Investigator Hans, I do feel for him that is a very difficult and technical thing to have to testify about. But what I think really we got from that, and it may seem obvious, is that the person whose account is registered to the phone doesn't mean that's the person who has the phone. I think we can all understand that. And we know that these phones that are associated with Tanya Tripp and Janelle were never recovered. And because we don't have those phones, an extraction could not have been done. An extraction that could have potentially showed us messages between the two, interactions between the two, that could have shed light on something. But we don't have that, so we don't know. What we also know is that the Tate Road residence was not even looked into until about a week after the initial missing persons call. According to Investigator Sylvester, it wasn't until April 25th that anyone from Richmond County Sheriff's decided to do a walkthrough of that house. This walkthrough, again, is done a week after the initial call. And there had been some law enforcement in the house before. We saw Deputy Cook interviewing Ms. Tripp in her living room. But there was no walkthrough. There was no asking to see the rest of the house, to potentially see Janelle's room. None of that happened until a week after the missing persons initial report. Why wouldn't that house be one of the first places that is looked at when this girl is reported missing? What we also know, again, through Investigator Sylvester, is he got the Facebook records. Janelle was very active on Facebook. What we also know is that her Facebook activity stops Easter night at 8:15, 3 to 4 hours before Leon Tripp comes home. And the last thing that we do know is that there was no trauma to the bones other than post-mortem trauma that could be due to animal activity. Both Dr. MT and Dr. Gooding, both experts in their field, looked at those bones and both confirmed they did not see any type of trauma to the bones that would have occurred before or at the time of death. So that's what we sort of know. But what I think is more important is, what do we not know? What has not been proven to you? Well, the first thing that hasn't been proven to you is that there was ever an inappropriate relationship between Janelle and Leon Tripp. There has been nothing but conjecture about that. There have been attempts to try to put that into the minds of you through questions, but there has been no actual evidence of that. And believe me, if they had actual evidence of that, you would hear about it. They would present that. That would be huge. But there was nothing other than speculation and conjecture. And honestly, to start to try to ask questions about a pregnancy or to try to get people's opinions on how the appropriate way for a 16-year-old girl is to dress and act without any other evidence about there being some reason to question that, I think that's really inappropriate. Now, what also hasn't been proven is that shovels in the bed of a truck equal commission of a crime. As we noted, there were other tools in the truck. Willie McLeod told you, Leon Tripp did work as a landscaper. This was his work truck. There is no proof of anything related to these shovels, and having a shovel in your truck is not illegal. Without anything else, that's all we have. Now, the other thing that I do not think the state has proven is that Leon Tripp's statement on June 9th, the last one we watched, I don't believe that was voluntary. And you probably understood why based on my questions to Investigator Grant. But first and foremost, I don't understand why Leon Tripp was even there in the first place. Because when I asked Investigator Grant, why is Leon Tripp even being brought to CID, the Criminal Investigations Division? He said, well, it's because someone told me he wanted to talk to me. But Investigator Grant confirmed that is nowhere in his report, and he just remembers it from 9 years ago. So that's what happened. I have a difficult time believing that. And I would argue Leon Tripp should have never been there in the first place. Now, even beyond that, then, his right to counsel. That is a fundamental right. We all know that. Lawyers know that. Cops know that. Normal people know that. And when you're interviewing someone and they ask for a lawyer, you stop and you don't talk to them again until you have their lawyer. We saw, and Investigator Grant even acknowledged, he went back in. An hour or so had passed, too. It wasn't just a quick, let's finish this up again real quick. No, an hour had passed. And he goes back in there and says, I gotta go through Miranda. Even though he said at that point, Peter Johnson, Leon's attorney, was at CID. He decided to go in by himself to reinitiate conversation with Leon. And I know the state is going to say, Leon was the one who initiated the conversation. Leon's the one who started saying stuff. But while he's saying stuff, he's also again reiterating he's not supposed to talk to you without his attorney there. And again, it's clear he's starting to try to talk about things related to the case. And instead of leaving the room and getting his attorney, who I presume was down the hallway, Investigator Grant stands there, kind of waiting, maybe getting some more information. And then beyond that, he lets in Sheriff Richard Roundtree. He introduces them to each other. And then he leaves Sheriff Roundtree in the room alone with Leon to go get his attorney. And so we finally see at the end, Peter Johnson is there. Leon Tripp's attorney, who he has asked for from the beginning and who has been at CID, is the last person to walk in there. And he finally is advising Leon Tripp the way he should have been advised in the first place. And so I would argue to you that statement is not voluntary. And as the law will be read to you, if you don't believe it was voluntary, you don't consider it. You just don't consider it. But if you want to consider it, what I'd also say is that the state has not proven that the statement, he'll tell you where she's at, is a confession to anything. And I think Ms. Dixon actually said it's actually just a bad statement. Maybe. But they made it sound like in their opening we were going to hear this bombshell thing. And it's just, maybe I'll tell you where she's at. It's not a confession to anything, and in fact, it really doesn't tell you anything at all, especially when you consider that there is no other evidence around that. Just him saying that one thing. We also don't know when the body may have been buried. Dr. MT and Dr. Gooding both specifically said they were not asked to do a determination of how long the body may have been buried. The state tried to get them to hypothesize a bit with questions, But what it comes down to is they both said, we did not do this evaluation in this case, and a variety of factors would impact this. And the fact that this was even ruled a homicide at all, that came from the medical examiner, Dr. Sandra Reynolds. And she was one of the only doctors that actually said she likes to consider the investigative report, and she likes to get all the background information to help her. As opposed to Dr. MT, and I believe even Investigator Newsom, who said they don't like to get the extra details. They don't want that to affect what they're doing. But the one person who decided that this was a homicide is the same person who said those bones to her would look the same as if that person died from choking. But I decided this because of the investigative report and the details I was given outside of just looking at the body, the bones. And even with that, Dr. Reynolds says there was nothing to determine how Janelle died. And that's sort of what the state is leaning into. They're trying to throw conjecture at you in the hopes that you'll make a case out of that for them. We had made it through several days of testimony before all of a sudden these questions about strangulation started to come up. And these questions had to be posed as hypotheticals. If I strangled someone and moved their body and there was no blood, would there be any evidence? They had to be asked in hypotheticals because we don't have any actual evidence of any of that happening. But they want to start giving you just these ideas that are not grounded in evidence so that you will run away with that and come up with your own idea of what may have happened based on nothing we have actually heard in evidence. And so ultimately, what the state has not proven is how Janelle died, where she died, when she died, who may be responsible, when she was buried, who buried her. They sat you here for a week and cannot answer those questions for you. And so that leads to the last question. Is it good enough? And we'll talk about the law a little bit, but as has been mentioned, the judge will read it to you. So I'm not going to stand here and bore you. But what I think is important, again, is this party to a crime idea. And the state presented what party to a crime is. But what they want you to do with party to a crime is they want you to say, we don't really know who did it. But that's okay if we don't really know, because party to a crime, we can convict both. And that is not how party to a crime works. Because you still have to know who was involved, how they were involved, before you can even get to the question of party to a crime. It's not just a, we don't know, so both. That's just not the way it works. Now, briefly I'll touch on conspiracy, and all I will say about that is there has to be an agreement. And they acknowledge it doesn't have to be spoken, but I've heard no evidence of any sort of agreement, unspoken or not. And the other thing I would say, is it good enough? The judge is going to charge you on a lot. But what I think is important is a charge you're going to hear called grave suspicion. And I think it's so important in this case that I'm going to read it to you. And it is only a sentence, so don't worry. But grave suspicion states that facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction. Conjecture and just thinking seems a little weird, seems like maybe he was involved. That's not enough. Grave suspicion tells you that's not enough. And that's important in this case because of the circumstantial evidence, which we have talked about, because largely in this case it is mostly circumstantial evidence. And my co-counsel, Ms. Burnham, told you in her opening to think of each piece of evidence like a brick. The state is trying to build you a house, brick by brick. They want their house to be proof beyond a reasonable doubt that the defendants are guilty. But you'll be instructed that to authorize a conviction based on circumstantial evidence, the proved facts must exclude every other reasonable theory other than the guilt of the accused. And they're going to point out it doesn't have to eliminate all other theories, that's true, but it has to eliminate every other reasonable one. And in this case, that just can't be done. And the state used an example of, I've been in court all day and I see people come in with their umbrellas and they're wet. Circumstantially, can assume it was probably raining out. That makes sense because you've eliminated other possibilities, right? What would another possibility be? These people came in and put their umbrellas under a sink. That's not reasonable. So that's a good example. But we don't have something clean cut like that here. Because consider these bricks. And if we're using these same bricks and we're able to build different houses, that means that the circumstantial evidence has not eliminated all other reasonable possibilities. And so for an example of that, consider one brick we have, and that brick is phone records. Phone records that could tell you Leon Tripp got back to Tate Road around, let's say 11:30 midnight. And then we see later at some point, Leon Tripp supposedly is going to Atlanta. So we take that brick, right? And the state's gonna use that brick to try to build a house, potentially, where the foundation is an idea that something happened to Janelle in that time, that Tanya and Leon did something to her. But that brick can also be used to build a house where Tanya Tripp's counsel says that all it shows is that maybe Leon came home, then he left with Janelle, like he told Tanya, and she didn't know. I could use that brick to build you a house with a foundation that rests on the idea that maybe something happened before Leon got home. Like I said, those Facebook records, that activity stops well before he arrives at home. So maybe he got home, came up on something he didn't expect or want to, didn't know what to do, and he left. Now, I want to be clear, that's not what I'm arguing. The defense, we don't have to put up anything. We don't have to put up any evidence. We don't have to put up any proof of innocence. But the point I'm trying to make is that any of these theories with what we have in evidence is just as likely as the other. You're building multiple houses. The circumstantial evidence has not gotten rid of every reasonable possibility other than the guilt of the accused. And I know this is a lot of information, and I promise you I'm almost done. But you're going to hear a lot about beyond a reasonable doubt. And I know you all have heard it. I know we've all heard that. But as Ms. Dixon was saying, it's a lot harder to actually understand in practice. So what I like to do is I like to compare it to going skydiving. So you're going to go skydiving. You're going to go up in a plane 10,000 feet in the air, and you're just going to jump into the sky. Now, the one thing that's preventing you from falling straight down to the ground is a parachute. Now, parachutes can fail. We know that if they're not properly packaged right, if they're not properly inspected. And here, the parachute is the state's case. They want you to believe that it's safe to jump. They want you to believe that this parachute will carry you down through the end. But as I pointed out, there's actually really hardly a parachute here at all. And there are so many reasons to believe that there are problems with this parachute. And if your mind is wavering, unsettled, or unsatisfied, the state has not proven this case beyond a reasonable doubt. Now, this is the only chance I get to talk to you. And so I take us back to that last question, is this good enough? I began my career in Augusta. I've spent over half of my career in Augusta. Augusta has been waiting for answers. And after a week-long trial, the state knows that they cannot and have not given you those answers. And they want you to speculate and come up with your own ideas. That's why they don't really have a coherent story. That's why the indictment says, an unknown weapon in an unknown manner at an unknown date. They're throwing anything they can at the wall to see if it sticks with you. And I get that that's tempting. But after 3 excruciating days of jury selection, probably for all of you just as much as anyone else, probably especially for all of you, after 3 long days of jury selection, we chose every one of you out of that panel because we are confident that you are the ones who can look at this case fairly and impartially, that you are the ones that can hold the state to its burden. And so I'd ask you not to do the job of the state for the state. For all the reasons I've said, but also because why do the job for people who can't even be bothered to get Janelle Carwell's name right? Her name is Janelle Carwell. Defense counsel has said it. Witnesses have said it. They've called witnesses with that last name who have spelled it for them. They put up a missing flyer with her name on it. And even still, this entire week, even starting in jury selection, neither one of them could be bothered to realize they keep saying Janelle Carswell. Even reading from the indictment in their opening a few minutes ago, reading from the indictment, which I will tell you is correct and says Carwell, still said Carswell. It's disrespectful and it's unacceptable. Leon Tripp is not a murderer. Leon Tripp is not a mastermind. I would ask you to hold the state to its burden, to consider the evidence or really lack thereof in this case, to ask yourself, is this good enough? And to do what the law requires. And the law requires you to find Leon Tripp not guilty. Thank you.
Thank you, Ms. Stengel. Ladies and gentlemen, do you need a break at this time? All right, we'll take a 10-minute research.
All rise for the jury.
All right, be seated, please. Anything before we take a recess from the state?
Nothing to say.
Ms. Stengel, Ms. Burnham,
No, Your Honor.
Mr. Regis?
Nothing, Your Honor.
All right, we'll be in recess for about 10 minutes or so.
How you gonna do what?
You need a rubber band? Here, I guess. Get one base. Oh, she's going back to the original?
Yes. Steve Bell's your daddy. Messing with my stuff.
You got a check for me? Nice.
No, I got some, I guess a guy met me out in the parking lot this morning, and, all this, subpoena for deposition, James Garcia shooting stuff. I wasn't there, it was at home, when he was working, I just said, why need a deposition? And look, they want me a deposition on next week. I gotta get this accounting thing.
Because there's a few things that I had done on the first contact. This is sick.
Okay, witness check.
I did for him, but I sit there and say, look, I don't know nothing. So I got at home. He called me, he said, I'm at the hospital. I shot myself, I won't be on work today.
What's he doing? Still sick?
Yeah, him and Tim Roz and all them were in this thing.
Yeah, lawsuit.
I think we put down a thing in it, shot me.
If you wanna believe that stuff,
Yeah.
I shoot yourself in the butt.
Especially if you're putting your gun in the holster.
That's what I'm saying.
Well, yeah, just, make sure that, you're getting phone calls about everything.
I'm sure.
Keep watching the video.
Yeah, they have nothing else to do.
Yeah.
They should be at work.
Let them off the screen.
Hmm?
Let them off the screen. Was he just,
You got 400 people watching, so you're gonna have to make more reporters.
was he just saying that to cover it up? Make sure we're not
Usually,
micromanaging.
Captain's here, which is.
Have sleep right now.
Yeah, he don't watch this shit. But you're gonna get, that's just normal, you know that.
There he is.
And it might even be one on you.
Charles Kramer.
Even though no camera can see you,
Yeah.
they'll still have it on you because they're
Yeah.
what, the camera cop, I call him the camera cop. Randy Horton, he'll have a complaint, he'll take it to Chad, Chad looks at it, yeah, I saw you did this, you know they didn't get it from any other thing. I'll be on there. I said, so how stupid y'all are. Luckily you hadn't had that, but hopefully you don't. There you go.
That's down here.
You're gonna go. Oh, I know.
A lot of that's. Because it's yours, it's a shirt.
And yeah, Judge read me a bunch of charges. Well, that's true. So, imagine.
Mr. Johnson.
What is this do? Is that what it is? So, I thought we had spinners.
All right, we got spinners, we got little squishies. I heard you were about to shake your head when your name came up.
I didn't think I was gonna come up with it. You kinda had to. You kinda had to. Switch the Chair, it just makes me feel easy. By the DA.
Which I know.
Natalie.
Okay, then she's not over here.
So, but you made it sound like, oh, you had an attorney, so everything's cool.
Well, no, that's what the court is. Regardless of what I
And here's the thing.
You did.
Well, apparently, I told him not to talk to the court. They wouldn't talk to the court.
I hope these mics clean. I hope these mics.
One day we'll have to sit down and have a talk.
I'm just right to go.
Hey, just cast me correctly in Netflix series.
Okay.
She wants me to be like, hey, I'm not going to I think he's gonna make a career come out with another national treasure.
I think that's a great act.
Have you watched comments?
Most of this movie, most days off. I watch it.
Public rubber. Southern accent.
For the movie itself.
That's okay, incredible. Hands out. God.
Yeah, but I think you
Be careful now. And every time that I do my phone call, I am, is it qualified?
All right, we'll be back in session. I'll call line three.
We have the form of the verdict is for attorneys to, y'all can be seated, I'm sorry. You can look at it and
Miss Reagan, okay? No, you're.
I was just saying, I did the defendant separate. I figured it'd be easier to.
No, yeah.
Yeah.
I've never understood people that go to a coffee shop and go get coffee. It's like,
It's a donut shop.
It makes sense.
give these charts out.
she'll go to Starbucks and it's like, raspberry, cream cheese, something. I'm like, oh, okay.
Legitimate. I appreciate it.
Like pulling, salad, right?
All right, we're back on the record. Defendants are present in the courtroom with counsel. Anything from the state before we bring the jury back in?
No, sir.
Ms. Stengel, Ms. Burnham,
No, Your Honor.
Reagan?
Nothing, Your Honor.
Okay, all right. We can bring in the jury.
All rise for the jury, please.
Be seated, please. At this time, we'll have Mr. Regis close an argument on behalf of Mrs. Tripp.
Love, Lives, and Leon. I'm glad to know that Leon's counsel thinks it's cute and catchy. But at the risk of sounding cute and catchy again, it's also correct. It's also correct. Because Tanya Tripp was the victim of Leon. She was a victim of Leon's lies and Leon's love. And you don't have to believe me. You don't have to believe me. Believe Leon. And at the risk of sounding cute and catchy again, who are you gonna believe, the lawyer or Leon? Because what the lawyer said is that Tanya is the mastermind, but what Leon said was that Tanya didn't do shit. His words. So who are you gonna believe, Leon or the lawyer? I'm sorry, I needed that break more than anybody, but it didn't do me as much good as I hoped. Because this is wrong. This is wrong. This is wrong. On June 2nd, when Leon sat in that police interview room, his initial response was, "Why y'all arrested my wife? She wasn't in the truck. Why y'all arrested my wife? She didn't do anything." So who you gonna believe, Leon or the lawyer? And then later on in the interview, when Detective Sylvester said, "What happened between Tanya and Janelle?" And Leon said, "Ain't nothing happened between them." So who you gonna believe, Leon or the lawyer? And later on in the interview, what did Tanya do? Tanya didn't do shit. She wasn't in the truck. That was June 2nd. So who you gonna believe, Leon or the lawyer on June 2nd? But wait, there's more. June 9th, he sat down again in the interview room. And he said, "My wife ain't done nothing wrong except being with me when she shouldn't have been with me." So who you gonna believe, Leon or the lawyer? I hope that's not cute or catchy. My wife ain't done nothing wrong but being with me when she shouldn't have been, because Tanya was with Leon at that U-Haul station. So who you gonna believe? He said 4 times about, "My wife ain't done nothing wrong." Nothing happened between Tanya and Janelle. Tanya Tripp loved Batman. She loved him. Because as you heard in one of her interviews, she talked about Leon would never do anything. Leo was the only dad they knew. He would never hurt those girls. "I feel so safe when I'm with Leon." That's what Tanya said. Tanya chose love over logic because none of the other stuff made sense. She chose love over logic, and please tell me that's not too cute or catchy. She said Leon was everything to her. If he doesn't pay for it, we have nothing. He's my world. Talk about time, Tripp. This is wrong. This is wrong. When Leon sat in that room and said, "My wife hasn't done anything wrong but being with me," well, it still continues to this day because she's done nothing wrong but being with him, and she's still sitting with him. She's sitting right here behind him. She's still with him. And that's the only thing she's done wrong, is that she's still sitting with him as a defendant. And she did nothing wrong. Yeah, she's a victim of love, lies, and Leon. And he knows it. He knows it. Let's talk about Tanya Tripp. Tanya Tripp took her daughter to school plays and PTA meetings. On April 6, 2017, Tanya Tripp was at the dentist with Janelle for a routine dental visit. And sometime between April 6th and April 16th, she decided to kill her. I guess she'd gotten her money's worth for that routine visit. She didn't need to wait another 6 months. So who you gonna believe, Leon or his lawyer? On April 16th, it was Easter, Tanya took her girls to Easter church, Easter service, took a picture of Janelle wearing that yellow outfit, came home, they were cooking out. Leon is wherever Leon is. Told Leon we need plates, we need charcoal. Eventually Leon comes home. He stays there a little while with his buddy Will. They leave. They go to Will's house, they go to Maurice's house, go to Will's house, they sit around, drink, talk trash. Tanya's at home. When Will leaves sometime that night, Janelle and Tanijah, they're playing with the dog. Tanya's not feeling well. She goes and lies down. In opening, Mr. Mullins talked about the way he normally does an opening and how he does this and how he does that and the various other technical and fancy things. I'm not technical, I'm not fancy. I don't do PowerPoints. I think he offered me to let me use his PowerPoint yesterday. I don't know how to use a PowerPoint. Chalked it up to being old, I guess. But my way is different. I don't write this stuff down. I take a few notes here and there. And what I normally do, I can't really do in this trial. What I normally do is I look to the person I have the honor of representing. I look in their eyes and I feed off what their eyes give me. I can't really do that in this trial because Tanya's eyes, they don't give me much. Because for the last 10 years, she's been weighed down with the burden of being branded a killer. A killer of her daughter, Miss Thing, as she called her. So her eyes don't give me a lot. But this is the beginning of the beginning. And yes, she's been the victim of lies, love, and Leon, and I'm asking you, do not let her become the victim of law. Eventually, Leon comes home, 11 o'clock, 12 o'clock. Tanya's looking for him. She calls him. He says he'll be home in 5 or 6 minutes, and he gets home in 6 or 7 minutes because she timed him because she's controlling. Controlling. He's the victim of her? Who are you gonna believe, Leon or the lawyer? He comes home, stays for a little while, and he goes and gets Tanya's phone. He says that. He said he went and got Tanya's phone. He said that. He controlled that narrative. Not Tanya. Who you gonna believe, Leon or the lawyer? He said he went and got Tanya's phone. He said he was going to Clark's Hill at some point. He said that. And he said it because Tanya wouldn't want me to leave. Tanya wouldn't let me leave. I've tried to leave before, and Tanya said, oh, no, don't leave me. He came up with that, I'm going to Clark's Hill. And he knows it. He knows it. Tanya hears the door close, hears the car start. And she goes back to sleep. Until Tanija wakes her up at some point, be it 1:30, be it 3 o'clock. And says, Mommy, Janelle is gone. And Tanya says, what do you mean Janelle is gone? What do you mean Janelle is gone? She starts calling Janelle. She starts walking around the house looking for Janelle. And she doesn't see Janelle because Janelle left with Leon. And Leon said that. Leon said that. He said when he talked to police that Janelle left with him. So who are you gonna believe, Leon or the lawyer? I hope that's not catchy. She calls her phone. She calls and Leon answers. Babe, Janelle is with me. We went to Clark's Hill to help Maurice. He said that. He said that. But everything is fine. And Tanya says, okay, babe. Okay, baby. Just let me know when you're on your way home. And he didn't come home. And for the next half day or so, Tanya calls Leon repeatedly. And for the next half day or so, Tanya calls Janelle repeatedly. I think there's that call at 3:52 that they talk about when Tanya got Leon on the phone and they talked for about 3 minutes. 3 minutes. Long enough to say, babe, I have Janelle with me. We did the thing with the tire, the car, the Maurice thing. Everything will be fine. I'll be back. But before the call to Leon at 3:52 and some change, there was a call to Janelle at 3:52 and some change prior, and she didn't answer. She went back to sleep. And Leon and Janelle never came home. So what does Tanya do next? Well, she starts calling and calling and calling. She called or texted Janelle about 23 times or so in the next day. She called or texted Leon dozen or so times that day. She was looking for them. She was looking for them. She was looking for both of them. And how do we know that? Because she didn't just call them. She called Will. She had Leon's phone, and she went through Leon's phone and found Will's number and called Will. And Will sat right there, right here. raised his right hand, swore to tell the truth and all of that, sat right here and said that she called me. And all I hear on the other end was, I hear her crying on the other end, asking me where is Leon, about him going with Janelle. That's what Will said when he sat right here. So who you gonna believe, Leon or the lawyer? That's what Will said. And Will said she didn't just call him once. She called him, at one point he can even hear the police in the background. She was reaching out to whomever she could reach out to. Eventually, Will got tired of hearing from her. Will sat right here and said, and please apologize. I apologize for my language. Will said, bitch, stop calling me that. That nigga done kidnapped your daughter.
Wait, hold up, Mr. Regis. I don't want any type of comments whatsoever in this courtroom. I'm sorry, Mr. Regis. Continue.
That is what his friend told his wife. Because his wife kept calling his friend to look for him. Stop calling my phone. He done kidnapped your child. So who you gonna believe? Leon, the lawyer, or Will? Tanya calls police. And she tells the police, they're gone. She tells police what Leon told her. She tells police that Leon went to Clarks Hill to help his friend Maurice. And Leon took our daughter Janelle, and I haven't heard from either of them since. I've been calling and calling and calling, and I would say calling 23 times, but I won't. Or add another dozen or so for the time she called Leon, but I won't. But she called a lot. She called, she texted, she left messages, as well as again calling Will. Days passed. She heard nothing. She went to a friend's house, Miss Ernestine. Miss Ernestine said that it was Tanya and their younger daughter, Tanaja, who came in. At one point, Tanya left to get something, but before Tanya left to go get something, that child, that baby child, that Tanaja, was all up under her mommy, as a child would do, Miss Ernestine said. She was all up under Tanya. And then Tanya left to go get something, and then when Tanya came back, that girl, little Tanaja, was all up under her mom once again. Days go past, and nobody hears or sees Leon for almost a week. When Sergeant Dobbins was on the stand, I asked him, is there any known contact between Leon and anybody on the 17th after he left that house, or after 3 something in the morning? His answer was no. I asked him about the 18th, his answer was no. I asked him about the 19th, his answer was no. The 20th, no. The 21st, no. The 22nd. Nobody saw or heard from Leon or Janelle for a week after they left. Now they talk about Janelle's Facebook activity stopping around 8:15. Because the way it works is you can do a warrant to find out what someone did on Facebook. That is what the officer said they did. But what about if they said they didn't? What about Snapchat? And they said on the video, she uses Snapchat. Well, get a warrant for Snapchat. She uses Instagram. Well, get a warrant for Instagram. But they didn't. Somewhere around the 23rd of April, my wife's birthday. On the 23rd of April, Leon reappears. And I believe it was Assistant District Attorney Dixon who called an interview on Sunday. Let's call that the Denzel Washington interview. Well, the acting started well before May, because Leon brought out his best Denzel on April 23rd. Leon brought the acting skills out on the 23rd, where Leon came home and said, "Hey, where is Janelle?" You know, he knew Janelle wasn't there. Where's Janelle? Really? And Tanya's believing all of this. She put love over logic. She believed all this. She said, he didn't know. He went walking around, he went running around the house looking for Janelle and calling Janelle. And the Best Actor award goes to and she tells him, Tanya told him, "I'll call the police, they're looking for you and Janelle." Really? I thought Janelle was here. Let me go find her now, and turned around and left. And went and dropped the car off. And got a ride back to Atlanta. Tanya believed him. I don't understand that. Doesn't make sense. But Tanya believed him. And as I look into her eyes, trying to find my next word, again, I come up with nothing. Because she's been weighed down with the weight of 10 years of being branded a killer when she didn't. A husband that betrayed her, a community that abandoned her, and worst of all, a daughter who forgot her. So she believed him. And then his story became her story. He said she wanted to go to Atlanta for her birthday. He said he found a job and he was working. He said she got homesick and wanted to come home. He said he gave her some money to come home. He said he gave her directions on catching the train to the bus station to come to Augusta. She chose love over logic. That makes no sense. And even when eventually she talked to FBI agent Wright, every time he would say something like, Worst case scenario, you see, she'd shake her head, no, I can't go there. She talk about her faith. And I asked him, it was like she was in denial. And he said, yeah, it was like she was in denial. Because she chose love over logic. And sometimes there's a wide gap between the two. This just isn't right. You had Officer Smith, who was successful in getting Leon riled up to the point Leon raised his fist at him. He loved that. He loved that. He was smiling ear to ear when that happened. And he sat there and testified yesterday about going door to door canvassing and couldn't find Janelle. Nobody saw Janelle, as if there is this thing they are trying to say that somehow Janelle never left the house. But who are you going to believe Janelle left that house? But who are you going to believe, Leon or the lawyer? Leon told you Janelle left the house with him, but we couldn't find Janelle. I showed pictures of Janelle, and not one person said they saw Janelle. And they're right. And not one person said they saw Leon, because there is a week of time that no one can account for Leon. From April 17th until April 23rd, no one can account for Leon. We don't know what happened. They don't know what happened. Somebody does. And you know he does, because when he sat down in an interview room on June 9th, he said it. I'm tired. I'm tired. I'm tired. I want to resolve this. We can resolve this. We can resolve this whole thing. You mean you have information that can put an end to this, that can tell them what they want? Yes, I want to resolve this. Let me talk to my wife. Let me talk to my mom. Let me talk to my kids. I haven't seen my kids in about 10 years. I haven't seen my mom in about 10 years. Let me talk to my wife. Let me talk to my mom. Let me talk to my kids. I want to resolve this. I will show you where she's at. That's what Leon said. I will show you where she's at. I am not going to bother you with the triviality of whether they should have known that he shouldn't have spoken. He didn't have his rights. He didn't know this. I'm not going to bother you with that, because you heard what you heard, because he said what he said. And what he said was, I can show you where she's at. I can resolve this. My wife ain't did nothing wrong. So, the government, great attorneys. I will never be half as good as they are. Never. Great attorneys and good people. Really good people. They want you to believe that was a confession. However good of people they are, and they are, however great attorneys they are, and they are, they're often wrong, but they ain't wrong about that. They ain't wrong about that. That was a confession. I'll show you where she's at, and I have the information that can resolve all of this. Because they don't know what happened. She doesn't know what happened, but he does. But if you believe that was a confession, and it was, you have to also believe what remained was an exoneration. I can show you where she at. I can resolve this. My wife ain't done nothing wrong. That was not only a confession, it was an exoneration. Not the first, but the last. Because he'd already done it a week previously when he said, my wife ain't done shit. He said it again, my wife ain't done nothing wrong. So you have a confession, And if you accept it as a confession, accept it as the other part, an exoneration. And he knows it. And he knows it. Meanwhile, Tanya, doing interviews, defending Leon. So yeah, she's a victim of lies, loving Leon. She is defending him. My husband would never do anything wrong. He's my hero. He's my protector. He's our hero. He's our protector. She's defending him. She chose love over logic. He did nothing wrong. He would never hurt them. I hope that she's just out there somewhere looking for us. And I hope somebody will find. I hope somebody will find her. That makes no sense, but she chose love over logic because she believed Leon. When she was evicted, when she and Tanija were evicted, Leon came and got them. And that's how they ended up in Atlanta, because Leon is a person she relied on for everything. So yes, she believed Leon because she loved Leon. And Leon lied. He lied. And that's where we are. The state has proven that Tanya lied about being pregnant. And I think I mentioned a little while ago how sometimes when you choose, what was that cute thing I said? When you choose, I got it, love over logic, sometimes there's a gap between the two, a wide gap between the two. Well, the state has proven that Tanya lied about being pregnant. And as wide is the gap from love and logic, it ain't got nothing on the gap between I lied about being pregnant and I killed my daughter. Now that's a leap. That's a leap. But that's what they proved. She lied about being pregnant. Perhaps it was because she wanted to keep Leon. As he said, he would try to leave and she wouldn't let him. I'm pregnant, okay? I got cancer, brain cancer. How about lung cancer? She loved Leon, and Leon was her everything. And she wanted to keep him. But that's it. That is the one thing they proved, that she lied about being pregnant. And eventually, she admitted it. What Mr. Mullis told you on, I think Monday of last week, when you all were out there, and he was talking about their burden. Because as we are in America, Tanya has nothing to prove. Because that's who we are. We say that people who sit behind people who know stuff, people who ain't done nothing wrong but except being with him, people who sit as defendants have nothing to prove, because that is who we are. That's who we are. So when Mr. Mullins told you about the government's burden, he said, you're not here to try to figure out whether she did it or whether she didn't do it. That's not what you're here for. You are here to make the determination of whether they met their burden of proving beyond a reasonable doubt, whether they proved their burden. That's who we are. It's not about all the noise out there, all the wild stories and rumors. It's about what they proved in this room. And they proved she lied about being pregnant. That's who we are. And I appreciate, I've learned quite a bit about Mr. Mullins. I know his wife is pregnant, I know she's due today, and I just really appreciate that. And again, they're good people. I almost had dinner with Assistant G.A. Dixon a few days ago. Ran into him at a restaurant. And I would have eaten with them, but I don't want to turn my back on my drink. But good people, they really are. But the trial isn't about them and how likable they are, or about me and how, well, whatever I am. It's about her, it's about him, and it's also about all of us. It's about, who are we? Who are we? Do we believe in holding the government to its burden? Do we really believe that? Do we believe we go back there and figure out, he said this, she said this, he said this, and draw lines and figure, I don't know. It's about whether they prove their case. I think back to when I went to my father's funeral, actually, in Port Sulphur, Louisiana. And they gave me the flag because he'd been in Vietnam. And at first, I didn't know if I was worthy of it. And I remember when the officer, who happened to be a member of the clergy, spoke, and he spoke about just what it means, what this flag means. It talks about the fact that he went to that foreign land to fight for our domestic land. And he talked about justice and just what it means. He talked about the fact that in this country, justice is everything. It's what the government must do to remove it. It's that burden that they must reach. My father was a veteran, but my wife was a veteran. I wasn't. But you don't have to get on one of those planes or boats and go to some foreign land to fight for domestic justice here. You can get in your car and you can drive to this courtroom and you can sit in those seats where you are sitting right now, and you can fight for who we say we are, the people who believe in justice, the people who believe that they must prove their burden, the people who believe that they cannot leave gaps from pregnancy, guilty of lying about pregnancy, to the gap of guilty about killing their daughter. That's not who we are. Because who we are, Tanya, is cloaked in innocence. She's cloaked. She's surrounded. And it takes more to prove guilt than she lied about being pregnant. The judge is going to tell you that if you have a grave suspicion that she's guilty, a grave suspicion and nothing more, it will be your duty to find her not guilty. Tanya Tripp is not guilty. She is not guilty. The judge is going to tell you that in order to find her guilty, you must prove, or they must prove, beyond a reasonable doubt. And everybody has stories and everybody has analogies as to what reasonable doubt is. I guess I may as well throw mine in as well. And I think about my wife and I were watching TV a couple weeks ago. And after almost 30 years of marriage, I made a mistake. And somehow the remote control ended up in her hands. And she did what I knew she would do, what she'd always do, find her way to a documentary. But this one I enjoy because it allows me to give my explanation of reasonable doubt. It was about this 7-year-old girl. Her name was Mary Kellerman. And how she wasn't feeling well one morning before school. And her dad gave her some medicine. And Mary went into the bathroom and collapsed and died. And then around the corner, the Janus family, several members of the family weren't feeling well. 3 of them took some medicine. And they all died. And the EMT discovered that the medicine was killing them. And the EMT discovered that the medicine was Tylenol, and Tylenol was killing them. And all this happened in a few miles outside of suburban Chicago. 7 people died total from tainted Tylenol. And what did Tylenol do? They took Tylenol off the shelves of every store in Chicago. They took Tylenol off the shelves of every store in Illinois, and every store in Augusta, and every store in Augusta, Atlanta, Des Moines, Sacramento. They took Tylenol off the shelves of every store in America, not because they had a grave suspicion that something would happen, but because they had a reasonable doubt. It's not about math. It's about we have a reason to doubt our product. You have a reason to doubt their product. They want you to believe it's a conspiracy, but they have shown nothing to show that Leon told Tanya anything other than what Tanya told authorities. They want to say that somehow Tanya got a shovel and she went digging, I guess, or she instructed Leon how to take a shovel and dig, I guess. But yeah, there were shovels in the back of that work truck. And when we asked Detective Newsom about, well, did you check the inside of that truck? And his response was, why on earth would we bother with such a silly task? Ha ha ha. That's the family vehicle. So let's follow that line of thought. At some point in the investigation and what they call processing the truck, he deemed it important enough in processing the truck to swab the bottle for DNA. And he thought it important enough to swab the Burger King cup for DNA. But no one thought it important enough to see whose DNA was on the bottle. And no one thought it important enough to see whose DNA was on the Burger King cup. So we won't know that Janelle had been in that truck. Or we won't know if there would have been blood at some point because he said, why on earth would we put luminol, which is the other product, why would we put something like that on metal? Those seats aren't metal. But what would that prove? That would only prove that she was in the family truck. Well, Tanya's prints were not in that truck. Leon's were. But because she lied about being pregnant, this whole case is about Tanya's strange behavior. This whole case is about Tanya's strange behavior. Strange behavior is not criminal behavior. I mean, this is Tanya's Tripp. This is Tanya's Tripp. A woman who took her child to the dentist on April 6th and apparently killed her a week or two later, I guess. This is Tanya's Tripp. A woman who took her daughter to church Sunday morning and decided to kill her Sunday night, I guess. They can talk about common sense. They can talk about common sense. I'll be sitting down soon, and as you know, I don't get to say another word. I wish I did. Because as you see, they'll be sitting here taking notes so they can come back and counter whatever it was I said. Well, I don't get to do that. But you can. When you go back wherever, I don't know, when you go back into that jury room, you get to ask the questions that I didn't ask. You get to ask. So, she was calling and calling and calling all night, both of their phones. And you get to ask, but she was calling and calling and calling Will, to the point Will cursed her out and hung up on her? You get to ask. You get to ask, wait, you have all these video and audio recordings, yet the guy with the FBI somehow can't record a phone call, so we don't know whose version of the story is true. You get to ask those questions among yourselves. I want one of you. Well, I want all of you to ask those questions. You get to ask, what did Leon have to gain on June 2nd when he said, y'all arrested my wife? She wasn't in the truck. She ain't doing anything wrong, but be with me. And when he said again, nothing happened between Janelle and Tanya. And when he said again, my wife ain't done nothing wrong. And when he said again, my wife ain't done nothing wrong. He had nothing to gain from that except telling the truth at that time. And when he said, I will show you where she's at, just let me talk to my wife and we can resolve this, and talk to my mom and talk to my children and we can resolve this. For 10 years, almost. And this is all they got? For 10 years. You can talk about, well, we told you from the beginning, it's only a circumstantial evidence case. You don't even have circumstantial evidence that Tanya Tripp committed malice murder. You don't have circumstantial evidence that Tanya Tripp committed felony murder. You don't have circumstantial evidence that Tanya Tripp committed aggravated assault. You don't have circumstantial evidence that she buried the body and lied about it. Both of those. You don't have now you have circumstantial evidence Leon did. He left with a living Janelle and returned without. He said, I'll show you where she's at. You have circumstantial evidence that Leon did it. Yet Leon is a victim of Tanya? So who you gonna believe? Leon or the lawyer? Leon was no victim. Leon was a perpetrator. Tanya Tripp was and is a victim. Tanya Tripp was a victim of lies, love, and Leon. But today is the beginning of the beginning, because you can make certain that Tanya Tripp is not a victim of law. And I thank you so much for being here.
Ladies and gentlemen, are you all right? Anyone needs a break before the state gives its concluding argument? That is all right? All right, Ms. Dixon?
Your Honor, if I can just use the restroom, I think we can hold everything in place, but I would just like to use the restroom before I begin.
All right.
I have a hard job following after Mr. Regis. He did a great job. He's very theatrical. You know what I am? I'm the granddaughter of a Pentecostal minister. So I'm not going to be theatrical, but it's right around lunchtime. Y'all have been here all week. I know you're probably hungry. I'm hungry. I know you're probably cold. I'm cold, but I'm about to take y'all to church. That's what we're about to do. This is the story of Latanya Janelle Carswell. Not just Leon Tripp, not just Tanya Tripp, but a 16-year-old girl who died the day before her birthday. Before we can start, we have to figure out the timeline. There are so many lies in this case. It's just a web of lies from both of them. But those lies lead us back to the same place over and over again. To both of them. Their conspiracy, we talked about this before, leads back to both of them. Timeline. And again, I know it's lunchtime. Please be patient with me. And I'm going to go through these kind of fast. But let's figure out what the evidence was from that stand. Timeline. Easter Sunday. Resurrection Sunday is what Miss Ernestine said. It was early morning service where she saw the girls. She saw Janelle, Tanya, Tanijah. Remember what she said? She looked at that baby's eyes and she could tell something was wrong. She didn't know what it was. She said, I wish I could have done something. But there was something not right in Janelle's eyes. That 7 o'clock Easter service. And she turned around and they were gone. It was the last time she ever saw her. Later on, 3 p.m., we got that cookout on Easter Sunday with Will McLeod. Remember, Will McLeod, Mr. Reagan said, that is Leon's buddy. He saw the girls there. I think he said they might have been playing with the dog. Everything seemed fine. And we're still on Easter Sunday. We're at 8:15. Janelle sends her last Facebook message. Throughout the trial, it's a lot of evidence. She is social. She's very social on social media. But 8:15 is the last time she sends a Facebook message out. And then at 11:30, Tanya calls Leon and asks when he will be at home. She says that to 911. She says that in her interviews. 11:30, she calls him. In fact, everybody agrees to that. She said she timed him. It was 5 minutes. Leon gets home about 11:30. They talk in the car for a while. Mr. McLeod testified to that. 12:30, somewhere between 11:30 and 12:30, Leon goes in the house. Now, the next morning, early in the morning, this is some of what Leon tells us. Leon originally says he's going to Clark Hill with Janelle. Now, when he's confronted with the evidence in that interview, he says, no, we went straight to Atlanta. He says Janelle doesn't pack a bag. And Janelle has no outgoing activity on her cell phone on the way to Atlanta. She's not picking anything up. So this is a 15-year-old, 16-year-old girl in a car, no activity on that cell phone going out. Now, there's things coming in, could be push messages, but she's not calling anybody, she's not texting anybody. Why isn't she? Now, and I apologize, Investigator Hahn, that is always hard testimony to get through. It is, with the cell phone records and all of this, and y'all see I have readers on, so I'm not that young. It is still all new for me. But what he told us was that at 2 a.m., Tanya's phone and Janelle's phone leave the Augusta area and they travel along I-20 west to Atlanta. Is west that way. So again, 2 a.m., they are leaving Augusta. The phone that belongs to Janelle, 4001. The phone, 1596. That is Tanya's phone, but they told you, they switched phones. So this is the phone that Leon has and is going to Atlanta, and Leon tells you he goes straight to Atlanta, and Janelle's phone going straight to Atlanta at 2 o'clock in the morning. Now, at 3:52, Tanya and Janelle's phone are in East Atlanta. And again, that's the phone that Leon has. They're east of Atlanta. And the time is at about 3:52. Now, I asked him about this green dot here. This green dot is an incomplete call that was made right here, 3:52 12. So this is a phone call to 4001. And again, because I need my readers on. But to 4001. And this is from the phone that Tanya has. She's calling 4001. It's 23 seconds, so it's not answered. Then after that, she calls her own phone. This is the phone that Leon has. This call is 174 seconds. What does she tell us about that phone call? She says she talks to Leon. She talks to her daughter, Janelle. She says Janelle tells her, "Mommy, I'm okay. I love you." So that's the last time she ever talks to her daughter. And that call's at 3:52 in the morning. That call's at 3:52 in the morning. And we can see it here too. No other calls. No other calls before from this number here to Tanya's number of 1596. Okay? It's this call in orange at 3:52 in the morning. Now, April 17th, that's Janelle's birthday. As I stated before, there's no outbound activity for Janelle's phone, no outbound texts or calls. But at about 8 p.m., Tanya calls the non-emergency line, which is 1080, and she reports Janelle missing at 8:30 p.m. She says they left around 1:30 on April 17th. She says they left at 1:30. 1:30. And then she says, I spoke to them. I called him. I said, "Hey, babe, you got Janelle." Okay, but that phone call's at 3:52. That phone call's at 3:52. It's not at 2 o'clock in the morning. It's not at 3 o'clock in the morning. That phone call's at 3:52. Again, we see where she calls 911 at about 8 o'clock. Let's listen to this 911 call.
I got the dispatch. ADOT, how can I help you?
Yes, ma'am. I was calling to report a missing person. His friend called him this morning about a little after 1 and asked him could he come help him because he was stranded on the side of the road. And my husband told him that he was tired. He said, "But I'll come on and help you," since she couldn't get nobody else to come help you. And he came in here and got my phone. He asked me for his cell phone. Don't have a map on it where you get directions. And he left, and him and my oldest daughter, they together. And I called him because I didn't know at the time that she was with him. And he said that, "Well, babe, since you weren't feeling good," he said, "I asked her would she ride with me because I didn't want to ride by myself, to go check and see if I can help him well." So I told him, I said, "Well, when you on your way back, honey, please call me and let me know that y'all okay." And he said, "All right." And I've been calling him ever since 3 this morning, and I still haven't got him or my daughter. And it's not like neither one of them not to answer the phone.
Okay, so your husband and your daughter are missing?
Right.
Okay. First off, she says it's a missing person. I thought both of them are missing, but she says it's a missing person. Let's think about some of the other things she said. She said that he came to her again at about 1:30 that morning. So why is the phone call at 3:52, right? But she also says her husband said, "I didn't want to ride by myself. I didn't want to ride by myself." There's no mention of GPS. There's no mention of navigation. I wasn't going to play the entire call for y'all, but if y'all want to listen to that call, to that 911 call, you know what to do. You write the judge a note, and he will let you listen to it. There's nothing about navigation. There's nothing about GPS. Then she says, "I've been calling him ever since 3 this morning." Well, at 3 this morning, she'd not actually spoken to them. But she's saying she's been calling since 3 this morning. And let's think about this. There's a big difference between 3:52 in the morning, that's 4 a.m., and 1 or 1:30 or even 2 o'clock. That's like Mr. Reagan said, that's a big jump. That's a big jump of a difference. And it's not like this is an insignificant day for her. This is the last time she's talking to her daughter. But she wants to say she confused 1:30 and 3:52 in the morning. It's lies. And again, we see that list of phone calls. And this type of evidence does not lie. The only time she spoke to somebody on the other end of the phone that she had was right here at 3:52. And that's her calling her own number, because as she said, they switched the phones. Let's get back on track a little bit. Deputy Cook arrives at about 9 p.m. And Deputy Cook is a little baffled too. It's like, why she want to take your daughter? Why did he take your daughter? What did she tell Deputy Cook?
Why did he take your daughter?
Because he said he didn't want to ride by himself.
Okay, that's the second time she tells it. He didn't want to ride by himself. That's what she says. There's none of this GPS. Did Leon tell her that? Or was it just when they were making up the story? They didn't get that detail with each other. Next day, we're about to move a little faster now. We're on April 18th. Miss Tripp calls Ron Sylvester. And that's the first time we hear about the GPS. But she hasn't spoken to Leon, right? So where is this GPS detail coming from? She didn't say it the 2 times she did before, but now she's talking about GPS. She calls the next day. She tells him, I think something bad has happened to them. And then the next day, we don't know about this at the time, but according to Mr. Tripp, this is April 19th of 2017. And what does Mr. Tripp tell us? He tells us he gives Janelle $400. And he tells her to take the MARTA to the Greyhound. He says she leaves from the house on Arlington. But then he tells another story at one point. He says he gives her $400 still. And just if y'all remember, I always thought this was really interesting. There's a part when he's talking about how they're about to be evicted and they're so poor and he's going to Atlanta to make money to feed his kids because he's the only one who's working. We had to go, I think, to the BP gas station and get jugs of water to cook with or something he says like that. Oh, but you give her $400? And you tell her to go get on the MARTA? Agent Wright said, I got a grown 20-year-old son. I wouldn't even do that for. But that's what he said. And that's what she believed, right? She believed that too. The other story, once they blow up the whole Arlington thing, the other story is, okay, we were at a trap house with some drug dealers, and if I tell you where this is or I send police, they're going to come after us. They're going to come after us. Okay? He says that, and they want you to believe that she believed that. She believed that. Sunday, April 23rd. Okay, Leon comes home. He drops off the truck. Everybody knows this happened. No one disputes this. Remember, at this point, there are no warrants for Mr. Tripp. Those warrants don't come until May 1st. So April 23rd, he comes home, he drops off the truck. Why? He's not wanted, right? I mean, like, why are you dropping off the truck? Now, Tanya also says she was driving to Atlanta and her car broke down. Did he bring home the truck because her car broke down? I don't know. But he brings home the truck, and then he goes back to Atlanta, but there's no warrants out for him. Okay, Leon's truck is found at 3001 Woodbriar Court. And the truck was not there at 1:30 a.m. Small witness we had, Mr. McLean. It's a desolate kind of empty street. I think you saw both sides of it. There's only 2 houses there. He thought it was real unusual. The keys are left inside of the vehicle. It's like somebody wants it to be taken. He said he thought somebody stolen it and it just left it there. And then the neighborhood canvas is done by Madden. We go to the next day, April 24th. That truck is processed. In the bed, there are unopened bottles of malt liquor, Ice House beer, and vodka. Inside, there was an open Corona light can, and those shovels are in the back. All right? And we made a big deal about the DNA in the truck. Okay. Janelle was his stepdaughter. Janelle had been in that truck before. So again, if there was DNA in that wouldn't tell us anything. I asked Investigator Newsom, could you have even told when that DNA would have been left? No. No, and he explained to you. He looked with his naked eye, he didn't see any blood. Even Madden said he kind of didn't look like there was anything that had happened in there. And when her body was traveled, when her body was placed in that truck, on the 17th of April, it wouldn't have left any type of bodily fluids or any type of blood. But we'll get to that. Okay, again, on April 23rd, and again, Mr. Tripp had been at the house the day before. Investigator Madden talks to Tanya at her house, and she says she hasn't had any contact. And we know that's a lie. It's not just pregnancy. There are lies after lies from both of them. He's telling them, she's believing them, lies after lies. April 23rd, 2017. Mr. McLeod, right? I don't think I'm that theatrical to go sit in that chair right now, and I got this skirt on, right? Sometimes it's hard being a woman. But Mr. McLeod came in his courtroom. That's his buddy, right? And Mr. McLeod did say that. He did say, yeah, I told that B, that N done took your daughter, or they went, or whatever he said exactly. Okay? So he knew what time it was. But she's saying she didn't know what time it was. His own boy is telling you what time it is. He's telling you that this don't smell right, right? And Will McLeod's not the only one who thinks that this doesn't make sense. Now, April 25th, Investigator Sylvester goes to 3103 Tate Road and he does a walkthrough. He says it's not a search. And I think somebody suggested, they should have searched this house. Okay. God forbid my sons go missing. Okay? They want to come and search my house. At that point, they weren't thinking that she had done something. We know it now. Okay? So he did a walkthrough. Now, if she had told law enforcement 2 days before when Leon had come home, maybe they would have searched the house. Okay? But they have a good 18-hour head start on law enforcement. But again, on the 25th, she doesn't say anything to Investigator Sylvester. 26, Investigator Sylvester calls Tanya Tripp again. She's got no information to provide. And again, she doesn't say, I've been in contact with Leon. The 27th, Investigator Sylvester goes to Tanya Tripp's home. She tells him that she was sure Leon Tripp did not take Janelle against her will and that he never abused her. She believes they were both set up. Something's happened to the both of them. Again, marriage is a great thing, right? Till death do you part. That's the best conspiracy ever, okay? We're in this till death do us part. We're not gonna say anything about each other, right? We're gonna let our lawyers do it. We're not gonna say anything about each other. We're gonna be together. And that's what they're doing here. Later on, he's telling investigators, my wife didn't do anything. She's kind of vouching for him. Because again, they're in it together. They have both done something to this child. April 28th, Renetta Du Bois interviews Tanya Tripp. And what did she say? After that, she started covering it every day. Now, even as Miss Tripp didn't think the Richmond County Sheriff's Office was doing their job, the community was. The community has rallied around this baby. That's why this courtroom is packed, because the community has rallied around Janelle Carswell, especially Renetta Du Bois. April 29th, Carl Wright talks with Tanya Tripp and she hangs up the phone on here. I'm not gonna go back over this, but the FBI calls me and I'm looking for my child? I'm not getting him off the phone. I'm getting his number. I'm calling him back. Okay? I want to find my child. Again, on May 1st, Investigator Madden goes to Tanya Tripp's home, and this is her first recorded interview with law enforcement. Again, she doesn't mention that Leon came home on April 23rd. It's on that day that Madden takes out warrants for kidnapping. And let's look at the week of May 1st. Tanya Tripp does Facebook Live with Pastor Angela Hardin. What does she tell Pastor Hardin when she says, hey, can you put some of these rumors to bed? What does she tell her? She says, Leon is my husband, not hers. Leon is my husband, not hers? That's what Ms. Tripp says. Leon is my husband, not hers. Also at the same time, Pastor Hardin starts doing vigils for Janelle. And one of the things that Pastor Hardin testified to was that there were no tears in Ms. Tripp's eyes ever for her daughter. No tears. No tears. It's like when they talked about how, you know, she was calm, and she was calm when she was talking about her mother too. It's because she knows a child is dead, just like she knows a mother is dead.
And all this craziness about they ran off to be together and stuff, no, it's no truth in none of that. That's her dad, that's his daughter. That's it. I'm his wife, not her. So all that craziness, there's no happening to that. Okay.
I'm his wife, not hers. Why is that even crossing her mind? I'm his wife. Now, you're comparing your daughter to yourself? May 2nd, Tanya calls investigator Sylvester again and asks for updates. She's aware that Leon Tripp has warrants. She even tells Renetta Du Bois she's not happy about it. You're not happy. You want some movement on your case, but you're not happy that there are warrants for your husband? Because you know what your husband has done, because you were part of it. Again, she doesn't tell Sylvester that she's been in contact with Leon Tripp. But what does she do? She makes memes. She plays on her phone. She sends this one to Pastor Harding. She does the Renetta Du Bois interview. And Renetta tells us that there are searches going on. Like I said, the community rallied around this case, okay? People are passing out. It's hot. It's May. It's going into June. People are hot, passing out, looking for her child, looking for his child. And where is she? She didn't participate in any of these searches. And what did she tell Renetta?
He married to all this prettiness and he gonna run away with our daughter? Come on now. That's stupid.
Okay. Again, what's she doing? She's comparing herself to her daughter. Married to all this prettiness? And Renetta's interview is great because she's asking those hard questions. But there's no answer for why are you saying all this prettiness, he wouldn't be with my daughter? There's no good answer for that. Okay, May 8th, Tanya Tripp calls investigator Sylvester and asks for updates. And then we have a big kind of block in between where she does not call investigator Sylvester. What do we know that she's doing? Well, Miss Ernestine said that she was praying together with her and she would always focus on Leon. Pastor Hardin, Renetta Du Bois, as well as Aki, all noted that she was focused on Leon Tripp. She also starts a GoFundMe page for herself, and Investigator Dobbins asks her, what is this GoFundMe for? And she says, it's for gas and hotels to try and look for my daughter. Well, why would you not be looking for your daughter in Augusta? It's right here. Okay, what is that GoFundMe page really for? Now, May 8th through 22nd, again, she's not calling Sylvester for any updates. She's not showing any bit of crying or any bit of emotion. At this point, your daughter's been gone for 2 to 4 weeks. Your daughter's been gone for 2 to 4 weeks. If my sons, I couldn't get out of bed. I couldn't get out of bed. But she's calm as a cucumber in those interviews. She's not crying. She's looking at the camera. She's sitting there. In the interview with Renetta Du Bois, there were some points where I guess the younger daughter is jumping up, and that's kind of almost the only emotion she has in that. She looks at the daughter and makes this nasty face. But other than that, she's just the same as she always is, because she knows where her daughter is. She's not looking for that child. Now, Monday, May 22nd, 2017, investigator Sylvester arrives at 3103 Tate Road. And what does he see? All the stuff is outside. She's gone. Tanya's gone. She didn't pick up the phone and say, hey, Investigator Sylvester, I'm going here. Please contact me if there's any leads on my daughter. She does not say any of that. She just leaves. She leaves, and he comes, and the house is empty. The next day, 8:45 a.m., she calls Investigator Sylvester, and she asks, is there any new information? Where is she probably when she makes that phone call? She's in Atlanta with Leon. They've just moved. And he tells her, no, Miss Tripp, there's no new investigation. Do you have any new information? And she says, no, I haven't had any contact with Leon. And there's a part in one of those interviews where they ask Leon, were you with her when I spoke to her earlier this day? He says, probably so. But she's telling law enforcement, and she keeps telling law enforcement, I don't know where my husband is, but you're in contact with him. 9:30. We had the U.S. Marshal, James William, come and tell you. About 9:30, he's been conducting surveillance for Mr. Tripp. He sees Mr. Tripp driving the U-Haul, sees Miss Tripp in a car. Leon gets out of the U-Haul, gets into the car, then he's arrested. And he has his first interview. And what he tells the investigators is, I assume, what he's had to be telling Miss Tripp all this time. He gives them that story about Maurice's car had broken down, so he asked Janelle to come with him so she could operate the phone. Now, mind you, Janelle has the same phone as her mom. Carl Wright tells us that, okay? They got the same phone. Tanya says that in an interview. They got the same phone. If you want to hear it, you write the judge a note, and I can take you to the place where that said in that interview on June 2nd. They have the same phone. So if Janelle has a phone that has the maps, why does he need his wife's phone? Again, it's part of the conspiracy. They're trying to throw law enforcement off. Okay. Let's listen to a little bit of Leon's first interview.
So I told my daughter, I said, Janelle, you know around me? Go check on all this car. I know, because your GPS, you know, work with GPS better than me. I'm not no technology person like that. I'm kind of old school and kind of touch screen and stuff like that. So, you know, she's like, yeah, but I know where she's going.
So he asked her in the middle of the night. I mean, they say maybe it's 1:30. I don't think that actually happened. I don't think that conversation happened. But we know the phone call's at 3:52. But he asks her, and she says, sure, she just wants to leave in the middle of the night with him. Okay. He states that after they helped Maurice, which we know that they didn't, he was going to take Janelle home, but she asked to come with him to Atlanta so she would go shopping. Again, he's going to give her that $400.
I mean, the next day was my daughter's birthday, so she was like, yeah, I don't know, I want to go with you for my birthday, you know. I said, I was like, well, yeah. You know what I'm saying? I said, I don't think, you know, mom should have, you know, she wouldn't even have with you. So, you know, we went to her house, you know what I'm saying? She had everything, you know. Like 3 days after that, you know, I gave her some money, I gave her $400. She said, yeah, I'm going to go shopping because, you know, it was her birthday, you know what I'm saying?
So that's what he tells investigators. I'm guessing Mrs. Tripp wants us to believe that that's what he told her, and she believed it. Again, he says he stayed at Arlington Street. He claims it's his brother's house, a brother named Greg. His brother owns it, but he doesn't live in it. He says the house had food. And he also says that he could not call his wife because the phones were stolen. He says the phones were stolen out of a truck when he was visiting a friend, And when he was visiting this friend, Janelle was at the house on Arlington. So again, if she made it to Atlanta, and let's be real, we all know she didn't make it to Atlanta. We all know she was dead before 352 in Augusta. But according to him, she's just at the house on Arlington, he's visiting a friend, and she doesn't have a phone. This is a 15, 16-year-old girl, and she don't have a phone. Okay, Leon says after 3 days, again, with Janelle without having a phone, she was chilling at the house and she wanted to go home. He gave her $400 to get the bus and to buy some clothes, but he didn't buy her phone. He gave her directions to the MARTA, and he sort of gave her a rough idea of what bus to take, what MARTA to take to get to the Greyhound bus. He also says that when he came to Arlington Street, she was gone. She was gone. This is what he told his wife. I came home and she was gone, so I assumed she made it safe, and I couldn't call Tanya because I didn't have a phone. And they say, can anybody validate that she was ever in Atlanta? It's like, no. No, we didn't get groceries, we didn't get any food. Nobody can validate that she wasn't in Atlanta, that she was in Atlanta, because she never made it to Atlanta. She never made it to Atlanta. She died in that house in Tate Road. He also tells them that he went home on April 23rd. And again, he told Tanya that when he got there, Tanya tells him that she's not home. And she says, hey, I've told the police that you were both missing. So he decides to leave the truck on Woodbriar. Again, even though there are no warrants for anything, right? Now ask yourselves, if Miss Tripp really believed that her husband didn't do anything to Janelle, why wouldn't she just call Investigator Sylvester? Why wouldn't she just say, oh, okay, so y'all were in Atlanta and now she's missing? Let's call the police so maybe they can call Atlanta police. She could have done that. Okay? But they want you to believe she just believed that story. No, she knew the truth because she was part of what that truth was. But that would have made sense. But her hands are just as dirty as his. They are both in this together. Now, she's also interviewed in Atlanta by Investigator Sylvester. She's over at that house in Arlington. And she tells them, as she was returning the U-Haul, she saw Leon walking down the street, and she stopped him. He then drove the U-Haul. But she says she had not seen him prior to that day before April 17th. Okay, she's more than just lying about pregnancy and cancer. She's telling them now, I haven't seen him, but she's been in constant communication with him. Why didn't she tell law enforcement that she was in constant communication with her husband? That makes no sense. That's more than love over logic. Okay, that just makes no sense. What that is dirty hands. Now, she's interviewed on May 26th, and she finally admits he did come home. I don't want to lie. I don't want to lie, because she's been doing a lot of that before. I don't want to lie. I don't know the exact date, but he did come home. And so Investigator Dobbins asked, like, why did you lie about bumping into your husband? Like, why are you telling all these lies? Okay, we're trying to find your daughter. We're trying to find your daughter, and what are you doing? You're lying to us. You're not telling us that you've had contact with Leon. You're sending us around in circles. Every moment that they are spent chasing down something that she is lying about is a minute that they are not going for or trying to find Janelle. But she doesn't care because she knows where Janelle is. But what did she tell Investigator Dobbins?
Right. So what was going through your mind at the time for you to fabricate or lie about that? What were you doing?
Stress. I was stressed that day, irritated, to be honest with you.
My daughter's been gone for about 6 weeks. I'm stressed. I'm irritated. I'm not, y'all, we still got to do something, okay? No, she's stressed, she's irritated, so she's lying to protect her husband, but it's not just her husband. She's lying to protect herself. All right, May 26th. Now, Tanya and Janelle are Facebook friends. But she basically tells Carl Wright and Investigator Dobbins, I haven't really been on Facebook, I haven't really been on Instagram. She can't be bothered trying to find her daughter that way. Again, she has that GoFundMe for motels and rental cars and gas. And then she's also making the app with the phony license. She says it's just for fun. Or she's trying to get out of town. Now, a big part of that interview is also her saying she's pregnant. They finally kind of get through to that, but again, instead of them being able to do their jobs, they're going down these rabbit holes that she is sending them on. And there's one thing she says in that interview to me, it just doesn't sit right. She says, I don't want my baby to wash up. I don't think anybody had said anything about washing up. Now, I mean, is she doing that to kind of deflect from the fact that, okay, maybe if I say wash up, they'll start looking in ponds? Because I know that she's buried. And then she also says she's got active cancer. But they spend time trying to research this oncologist to make sure she's healthy and okay. And that Dr. Levy does not exist. And now, before Carl Wright leaves, the FBI agent, he says to her, you're one of the most relaxed mothers I've ever met. And she says, because I haven't did anything. Okay. He's talking about the fact that your child is gone for 6 weeks, and you're not, I think he said, climbing up the walls. You're just like, I haven't did anything. She knows she's done something, you know, but she's trying to play it cool like she hasn't. So that response, I haven't did anything. No, you're actually playing it too cool. That was the problem. You played it too cool. May 30th, Tanya interviews with investigator Sylvester and Mark Dobbins. And Sylvester, he comes at the end and he says, I think he interviews her, she gives some more detail about Easter, and then he comes back and he just says, hey, like, why'd you lie to me? Like, you know, we were talking every day. You know, the first week or two they were, and then she breaks off in the middle of May. Why did you lie to me? And what she says is, well, he wasn't at the house the whole time. June 2nd. Can't forget about Mr. Tripp. Mr. Tripp has that interview with Mr. Dobbins. And an hour in, he says, I'm being 100% truthful. Now, he's then confronted with that cell phone evidence, and he says, oh, maybe I lie a little bit. Says Janelle wanted to go to Atlanta. It was her birthday, she wanted to shop. She didn't pack any type of bags because there were always clothes in the car. And again, he reiterates he gave her $400 even though they're about to be evicted. And then we get to June 9th. And this is the interview with Investigator Grant. What does he say? There's 2 things I want. I want to talk to my wife, and I want to see my other 2 kids and my mama. And I'll tell you what's going on, you know, where's she at and all that, you know, because I'm tired. But he wants to see his wife. He wants to be, honey, like, let's be done with this. Wants to see his wife.
You know what I mean? I'm going to go ahead and so y'all can close this case, man. You know what I'm saying? You know, because I'm tired. You know what I'm saying? But I want to see my 2 daughters and my mama, man. I want to see my wife. You feel what I'm saying? And I tell y'all, you know what I mean, what's going on, you know, where she at, and all of that, man. You know, because I'm tired. You know what I'm saying?
He's tired. And the sheriff himself, sheriff at that time, Sheriff Roundtree, comes in and talks to him.
I'm telling them what they need to know to close this case.
Okay. Does that mean that you do have information that they need to know?
Yeah, I have information. But I want to see my family before I close the case.
He wants to see his family, because he knows he's not going to see them for a while after. And that brings us to the end of Janelle's journey in this case. Brings us to March 8th of 2018. And I am going to show 1 or 2 of the crime scene photos. I'll let people know before that happens. All right. Janelle is found on Golden Camp Road. This right here, it's hard to see. Can we dim the lights? Golden Camp Road. That's that Tate house. That's the house on Tate, 3103. This is the map we showed before. Just going to show you how easy it is to go from Golden Camp Road to where Janelle Carswell is buried. And I'm still saying it wrong. I can have 1 second to figure out how to play this. So we're at Tate Road. Make a left. Make another left onto Golden Avenue. Then we're going to make a right onto Belmead Drive. We're making a left onto Golden Camp. Then we're at 2211 Golden Camp Road. Janelle never left that neighborhood. And I'm sorry, I said I was going to warn before I showed the picture, but I'm going to warn you the next picture I'm going to show is going to be graphic. Kevin Loverly just started renting the property. Wants to see where the property line is. Walks out. He sees bones. They come, they do the dig. This is what they find. Janelle's skull. There's maggots. There's the leaves. Brush over it. She's been put in a shallow grave. Janelle Carnwell said this is really a case about her. What I think is interesting, her mom gave a lot of interviews, and her mom always started the interviews off the same way. I have lung cancer. I have brain cancer. She never talked about who her daughter really was. The fact that she was a great kid, she was a wonderful sister. No, she played softball. She got excellent grades. You know, her mom said she did no extracurricular activities, but Lori Miles talked about the groups that she was in with her. She talked about how she wanted to be a doctor. The first time I met Ernestine Mackey, she told me Janelle could have done anything she wanted to do. She could have been a doctor. She could have been a lawyer like me. She could have been an evangelist. Could have been a preacher.
Objection, Your Honor, this is inappropriate. This is a conversation that she had with a lawyer outside the courtroom. Inappropriate.
Overruled.
And again, this is Miss Mackey. This is the church auntie. The church auntie. Janelle could have been so many things. But they didn't let her. Now, I want to look a little bit more about Tanya's involvement. How do we know Tanya's involved in this? Start with the very beginning. Miss Ernestine Mackey, the one who was telling me about all the wonderful things that Janelle could have done, you know what she told us? Like the first week, Tanya Tripp is annoyed with the investigators. You know, they're in my business. She says, you know, they're just doing a job. That's the first week. She's already annoyed with things. And most importantly, she doesn't tell them that she's got contact with Leon. I can't stress this enough. She talks to Sylvester almost incessantly, he says. But she never says, I just spoke to my husband. Again, she gets evicted. She can no longer stay in Augusta. She doesn't give a forwarding number. She calls the next day. She says no one is working on this investigation. But you saw the sheriff himself. Now, I've been working here about 6 years. I've never seen the sheriff go and try and help out with an interview. Again, this is the last sheriff. Community, like I said, the community was working this case. People are passing out. There are prayer vigils being held for her. She's everybody's daughter. She is everybody's daughter in this case. But who is jealous of her? Her mother. Her mother. We can tell that from watching those videos. And the other thing is the fact that she just refuses to be mad at Leon when everyone is telling her it doesn't make sense. Leon's friend said it doesn't make sense. Renetta Du Bois said, this is kind of puzzling. It doesn't make sense. You have to be. You have to be if you're a mother and you're married or you've got a partner. He don't come home and you're not mad. When y'all have that phone conversation and he's taking your child in the middle of the night, you're not okay with that. It's a school night. I mean, she says it's 1:30 in the morning, but we know it's probably closer to 3 in the morning, right? You're not okay with that? I have 2 sons. My husband likes to hunt, okay? If one day on a school night, he's taking them boys out at 4 o'clock in the morning because they like to go and do that early, if I wake up and my kids aren't in the bed, and I call him, Carl Murray, you got some explaining to do, okay? We're not taking that as mothers. You just don't do that, okay? When he called and told her that, but we know it didn't happen, should have been like, get my child back home. Have you lost your mind? Then, the calling. Yeah, I mean, you see that she's calling the phone. She's not blowing it up. You don't know where they are. She's back to back. I'm calling every 20 seconds. I'm calling, doesn't go through. I'm calling, doesn't go through. And her demeanor. Again, she's sitting like that when she's being interviewed. She's making these fake IDs. She's making these memes for Pastor Hardin, which is nice, but again, you should be nonstop looking for your daughter. She's not crying. She's the calmest mother ever. And when she's interviewed by law enforcement, by Renetta Du Bois, by Pastor Hardin, she's still just telling these lies to protect herself and to protect Leon. Now, I want to go back to Monday, April 17th, 2017. The lies start with 911 and Deputy Cook. Now, I touched on this, but I'm going to touch on it again so we're all really clear about what Miss Tripp did. So when she talks to Deputy Cook, what she tells him originally is 1:30. She says 1:30 in the morning. She says Leon comes into her bedroom and he tells her, I'm going to help Maurice. That's what she says. He tells me I'm going to help Maurice. But then, when she talks to Investigator Madden, she says Leon comes into the bedroom to get the phone. She hears the car crank up and the door slam. She thinks he's going to get gas. Those two things are very different. Which one is it? And again, this is the first story that she's telling. This is Deputy Cook. She says, Leon comes into the bedroom and he tells me he's leaving. Then about 2 weeks later, he comes in the bedroom and gets my phone. She's saying now, she didn't know where he was going. Okay, so that's how we know she's lying from the jump. You don't confuse those details. This is the last time you're seeing your daughter. You don't confuse those two details.
This morning my husband came in the room and he had said that he was going to help a friend that had got stranded on the side of the road. And he said that his friend told him that he had called everybody else, but he couldn't get them. So he said that would he come help him, and he did. So I didn't know at the time that my daughter went with him. And so my baby girl came in the room and she said, "Mommy, where's Janelle?" I said, "Ain't she back there asleep?" And she said, "No, she gone." I said, "Oh Lord." So I get up, go through the house looking, no Natanya. So I called my cell phone, because he has my phone, because he has, the map on it to get to where he can find his friend at, wherever. Okay. So I called my phone and I said, "Honey," I said, "You got Janelle?" And he said, "Yeah, I have Janelle." I said, "Okay." I said, "Have y'all got close to where he at or whatever?" And he said, "No, baby, we just got on the road." He said, "I just found the right exit to get off on." And he was saying something Hill.
Okay. They're just finding the right exit or so. And this is 3:56 in the morning, right, according to the phone records. But she said 1:30. Okay? So we got lies coming from the body camera. And she says here, she called him and she asked him, "You got Janelle?"
And then about 11:30, I had called him.
And this is when she talks to investigator Madden.
And I called my phone because he had mine. And I said, when he answered, and before I could even say anything to him, he said, "Babe, I got Janelle." And I said, "Okay." And then I started.
Janelle Latanya.
We call her Janelle. That's her middle name.
Okay.
And he was like, "I got Janelle." I said, "Okay." He said, I was meant to tell you that when I went there and got your phone, that I was going to ask her to ride with me to help me with your phone, he said. But I forgot, babe. I apologize.
Again, those two things can't be true. She's saying on the first time, I said, "Hey, do you have Janelle?" The second time, he picks the phone right up. And he says, "Oh, baby, I got Janelle. Don't worry." But those two things can't be true at the same time. And neither of those things happened. Again, 3:52. That's the phone call. 176 minutes. She says 1:30. It's 3:52 in the morning. That's when they talk. And again, when they talk, those phones are in Atlanta. And we know that from the phone records. Those phones are in Atlanta. Again, that's the phone number she used. That's what she had right up there. That's what you just saw in the phone records. But we all know, at 3:52 in the morning, Janelle is already buried because her phone is going to Atlanta. She never made it to Atlanta. Nobody could ever verify her. Miss Tripp, again, she talks about this phone call. She said, "Mommy, I love you." That phone call was at 3:52. He's already heading down with the phones. Okay? He's already heading down with the phones. She's saying, she's talking to her daughter at 1, 2, her daughter saying, "Mommy, I love you." But no, that conversation is at 3:52, and the cell phone records tell us that at 3:52, they are already outside of Atlanta. She never made it out of her neighborhood. She never made it out of her neighborhood. Why is Tanya telling these stories? Because her hands are dirty. The both of them. Now, it's true. We don't know how she died. We told y'all that from the very beginning. But why don't we know how she died? If we had found that body when Mr. Tripp came home, we might have been able to tell you that. But what's the reason we don't have any hard evidence in this case? What's the reason? They're good murderers. They're good murderers. They're good at digging holes. putting their daughter in them. Don't reward them for that. Don't reward them for that. If she had been found earlier, we might have been able to come in here and tell y'all this is what happened. I asked Investigator Newsom, what would you look for signs of choking or strangulation? He said a ligature. What is a ligature? He said it's a rope. It's a rope. I'm not sure which one it is, but y'all will have it in there. In that hole, what did they find? They found a cord. You should throw that cord in there with the body. But they found a cord in that hole with her. Okay? That's the one piece of evidence that we have that we know kind of happened. And I said, how do we normally look to see if somebody is choked? The petechia, the eyes. She's skeletal remains. She doesn't have eyes. But if she'd been found in April or May, then we might have been able to tell y'all. But don't reward them for being good. Don't reward them for burying her in a place where nobody found her. And don't reward them for pointing the finger at each other either now. It's easy to point the finger at the other person when you did it together, because you know some of what he did, and she knows some of what he did, but don't reward them for that, okay? They did it together. And I'm almost done, and I know it's lunch, I know you're hungry and cold, but I'm gonna go through this one more time. Party to a crime. You're authorized to convict a person as a party to a crime if you find that they directly committed the crime, if you find that he intentionally helped commit the crime, if you find that he intentionally gave advice, encouraged the crime, hired or paid someone, counseled them to go along with. Now, some people might think that Leon did this. Some people might think that Tanya, but hopefully I have made it clear. It is the both of them. You can look at their conduct, look at both of their lies, look at their efforts to mislead the sheriff's office. That was both of them. And I have there, everybody gets a Super Bowl ring. Because to me, that's another great way to think about parties to a crime, right? We had the Super Bowl a couple weeks ago. I can't even tell y'all who won, to be honest, at this point. But the winning team, everybody gets a Super Bowl ring, right? The guy on the bench, the quarterback, the coach, everybody gets a Super Bowl ring. Everybody is in it together. They are in this together. And how do you see the existence of a conspiracy? Another gold star moment. The presence, the companionship, the conduct before and after the commission of the crime. After the commission of the crime. Still being together, not telling law enforcement you've had contact with them, not telling them what you know. The state, we don't have to prove premeditation. We don't have to prove motive. However, proof of exact motive is not necessary for the crime of murder. But you're authorized to find the defendants guilty even if none of us know why specifically why they killed her. But here's what we do know. We know that we have a jealous mother, okay? She pretty much says that in the video. He's my husband, not hers. All this prettiness, why he gonna go someplace else? We have a stepfather, and we have a 16-year-old buried in a shallow grave with nothing but her bra on. Okay? Nothing but a bra on. No underwear, no pants. And looking at her life, who else? Who else but the people who are lying and covering it up? She had friends. She had a best friend. She had no problems at school. She was a good kid. She could have been a lawyer. She could have been an evangelist. She could have been a doctor. Remember reasonable doubt. It's not a vague or an arbitrary doubt. It's a doubt for which a reason can be given. So, if you can say, I doubt Leon and Tanya Tripp are guilty because of, then that is a reasonable doubt. But they're lies. Their lies cover things up. They're parties to a crime, working a conspiracy, killing their daughter. Again, their daughter who is buried in a shallow grave about a mile from the house with no underwear on. No personal baggage in the jury room. Now, it's been so long now, and I really am about to finish with y'all. But I think when I stood up here the first time, about 10 o'clock, I showed you that circle. We only consider the things in the circle. Don't bring your personal baggage into the jury room. Let the verdict be based on the evidence in the law, not on an agenda, not on issues with the justice system. You're not an advocate for either side. You are seeking the truth. That is your job as jurors. It's your duty. Seek the truth. Look at the evidence. And I believe that when you look through the evidence in this case, you will find the defendants guilty on each and every count. The judge is going to give you a verdict form when you go back in there. And as to count 1, we are asking that you find the defendants guilty. For count 2, we are asking that you find the defendants guilty. Count 3, we are asking that you find the defendants guilty, as well as count 4. And remember, when you come back with your guilty verdict form, you're not telling the defendants anything that they don't already know. They've known this for 10 years. Now it's time for justice for Janelle. Please come back with a guilty verdict on each and every count. Thank you.
Ladies and gentlemen, I would guess that at this particular point in time, you're ready for lunch. It's probably going to take me approximately 45 minutes or so to give you jury instructions, and I don't think y'all want to. I don't want to sit up here and give you jury instructions until I have lunch. Let me just be real with you. So I am going to, of course, your lunch has been brought in. So at this time, we're going to recess for lunch until about 2:15. Then I'll come back and give you the instructions on the law in this case. All right?
All rise in the jury.
Be seated, please. And Mr. Regis, I'm going to assume that you want to note your exception for your objection during the closing argument.
Yes, Your Honor.
All right. It's noted for the record. Anything from the state defense for Mr. Tripp and Mrs. Tripp before we break for lunch?
No, Your Honor.
All right. We will break for lunch and be back about 2:15. I'm just good.
Judge, I just want to be clear. Are you providing them lunch? Because I was going to get something from the food truck. I just want to make sure I didn't run into you.
Yeah, they have
Okay.
lunch.
I mean, I say, no. When I say, I say stand up, here it goes. And I.
Yeah, they threw out.
Yeah, you back up now.
I didn't know if we cut it off.
Yeah, we had it on like just, it's back up now.
Oh, yeah. Okay.
1, 2, 3, 4, 5, 6, 7, 8, 9, 9, 8, 7, 6, 5, 4, 3, 2, 1.
Marley. No, now. You just turned it back on? Thank you. You let us know. Doctor.
You have to keep him awake during this.
Dr. Rick, yeah.
I hate this.
Yeah, it's a tough one.
Yes.
I don't think that if he shuts him down at 5:15 or so, I don't think he'll ever worry about it.
I don't know.
Else closers got them confused enough there. At least yours is straightforward. It came straight out of the evidence.
Yeah. That's kind of my point.
Yeah. That's right. No smoke screen. Yeah, he's still, Michael Brandon's still. Come on here, Charlie.
Pretty day outside.
I do have a question for you.
Yes, ma'am.
I was going through the evidence.
Ooh, yeah.
I can't find that. had that it was tender, but I can't remember what it is. And then I have that, but I.
All right, we'll be back to session on the Charles Line.
Be seated, please.
Just trying to get it off straight.
I hear you got a whole lot more cases than our associate to do that.
I mean, I hope not. I don't know. I don't know the answer to that question. I really don't.
All right.
They would have been my mama's 98th birthday.
Wow.
She had hung with us.
Like you heard, it's Vaughn's birthday today.
Oh, okay. And so, we just got planned. Wait till the weekend.
I don't know about even then.
How old is she?
It's all right.
Oh, okay. Double nickel.
Yep.
I went through, make sure I have all the other. There's one that I was confused about. And I don't say it's taken in the court. She couldn't call me.
Okay. All right, we're back on the record in State versus Tripp and Tripp. And just also want to put on the record and for the attorneys to be aware that case of Boyd v. State, 306 Georgia, 204, 2019 case. One of the cases I looked at last night concerning given the conspiracy charge. So just wanted to say that. All right. Anything before we bring them in and charge them?
Not from the state.
No, Your Honor.
Nothing, Your Honor.
All right, we'll have the jury.
That's where Kevin can see that. No, I think
You think it's not urgent. Another link, you have an RSVP for mandatory
I don't expect it. Actually, I'll say at least a certain area.
Like the book community doesn't admit you keep it.
I got, it's hard.
And I'm confused about this one. I thought we just got it that we did. I haven't. But I just didn't know. I'm double checking you.
Admitted, 51's admitted.
Okay.
What's that? Huh? Let's see, what was that? The waiver form?
Yeah.
Yeah, we ready.
All rise for the jury, please.
Yeah, like, just let me know.
Be seated, please. Good afternoon, ladies and gentlemen. I hope you enjoyed your lunch. We have come to the point in the trial in which I will now read you the law in the case, and I will tell you you can put your pencils and paper down. You don't need it for the charge. The charge that I am going to read to you, you will have, I think, at least 3 copies of it in the jury room with you. So there's no need for notes during this part of the trial. I just ask that you listen as best you can to the charge. Also, I am going to try to do this without coughing, I hope, without blowing my nose, I definitely hope, and without losing my voice, I hope. But all 3 of those things are very possible. The charge is somewhat long, so if anyone needs a break while I'm charging, please just raise your hand and we'll do that, okay? All right. You're considering the case of State of Georgia versus Leon Lamar Tripp and Tanya Faye Tripp. The grand jury has indicted each defendant with the offenses of malice murder, felony murder, aggravated assault, family violence, and concealing the death of another. The indictment reads as follows. In the Superior Court of Richmond County, State of Georgia, the grand jurors selected, chosen, and sworn for the County of Richmond, to wit, in the name and on behalf of the citizens of Georgia charged and accused, Leon Lamar Tripp and Tanya Faye Tripp with the offense of malice murder, for that the said accused in the County of Richmond and the State of Georgia between the 17th day of April 2017 and the 23rd day of May 2017 the exact date of the offense being unknown to the grand jury, did unlawfully, with malice or forethought, cause the death of LaTonya Janelle Carwell, a human being, by a means and manner unknown to the grand jury, with an unknown object, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 2, the grand jurors aforesaid, chosen and sworn for the county of Richmond in the name and on behalf of the citizens of Georgia, further charge and accuse Leon Lamar Tripp and Tanya Faye Tripp with the offense of felony murder. For that the said accused in the county of Richmond and the state of Georgia between the 17th day of April 2017 and the 23rd day of May 2017, the exact date and the offense being unknown to the grand jury while in the commission of the offense of aggravated assault, a felony, did cause the death of LaTonya Janelle Carwell, a human being with an unknown object, said object which when used offensively is likely to result in serious bodily injury by a means and manner unknown to the grand jury, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 3, the grand jurors aforesaid, chosen and sworn for the county of Richmond in the name and on behalf of the citizens of Georgia, further charge and accuse Leon Lamar Tripp and Tanya Faye Tripp with the offense of aggravated assault, family violence, for that the said accused in the county of Richmond and the state of Georgia between the 17th day of April 2017 and the 23rd day of May 2017, the exact date of the offense being unknown to the grand jury, did knowingly make an assault upon the person of LaTonya Janelle Carwell with an unknown object, which when used offensively against a person is likely to result in serious bodily injury by a means and manner unknown to the grand jury, and said persons being the step-parent and parent of said accused, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 4, the grand jurors aforesaid, chosen and sworn for the county of Richmond in the name and on behalf of the citizens of Georgia, further charge and accuse Leon Lamar Tripp and Tanya Faye Tripp with the offense of concealing the death of another, for that the said accused in the county of Richmond in the state of Georgia between the 17th day of April 2017 and the 23rd day of May 2017, the exact date of the offense being unknown to the grand jury, did unlawfully conceal the death of LaTonya Janelle Carwell by burying LaTonya Janelle Carwell and by providing false information to law enforcement regarding the whereabouts of said victim, contrary to the laws of said state, the good order, peace, and dignity thereof. September term 2023, Investigator Lucas Grant, prosecutor, Jared T. Williams, District Attorney, Augusta Judicial Circuit. Both defendants have entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. A defendant is presumed to be innocent until proven guilty. A defendant enters upon the trial of the case with a presumption of innocence in his and her favor. This presumption remains with a defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that a defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon a defendant whatsoever, and the burden never shifts to a defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict either of the defendants. If the state fails to prove either of the defendants' guilt beyond a reasonable doubt, it would be your duty to acquit that defendant. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she actual knowledge. Let me do that again. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness, or such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference. That is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. The jury must determine the credibility of the witnesses. In deciding this, you may consider all other facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The testimony of the accomplice alone is not sufficient to warrant a conviction. The accomplice's testimony must be supported by other evidence of some type, and that evidence must be such as would lead to the inference of the guilt of the accused, independent of the testimony of the accomplice. It is not required that supporting evidence be sufficient to warrant a conviction or that the testimony of the accomplice be supported in every material particular. The supporting evidence must be more than that a crime was actually committed by someone. It must be sufficient to connect the accused with the criminal act and must be more than sufficient to merely cast upon the accused a grave suspicion of guilt. Slight evidence from another source that connects the accused with the commission of the alleged crime and tends to show participation in it may be sufficient supporting evidence of the testimony of an accomplice. In order to convict, that evidence, when considered with all the other evidence in the case, must be sufficient to satisfy you beyond a reasonable doubt that the accused is guilty. The sufficiency of the supporting evidence of an accomplice is a matter solely for you to determine. Whether or not any witness in this case was an accomplice is a question for you to determine from the evidence in this case. The testimony of one accomplice may be supported by the testimony of another accomplice. Whether or not the testimony of one accomplice does, in fact, support the testimony of another accomplice is a matter for you to determine. Any out-of-court statement made by one of the defendants on trial, in this case, after the alleged criminal act has ended, may be considered only against the person who made the statement, and only if you find that such statement was freely and voluntarily made. If you find that an out-of-court statement was made to the police freely and voluntarily by a defendant on trial in this case, then you are to consider the statement only as against the particular defendant who made it. However, a witness is not an accomplice if the participation by the witness in the criminal enterprise was unknowing. There is no legal requirement of corroboration of a witness whose participation was unknowing. Whether or not any witness in this case was an accomplice is a question for you to determine from the evidence in this case. A defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, a defendant does not have to present any evidence nor testify. If a defendant chooses not to testify, you may not consider that in any way in making your decision. A statement that a defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether that defendant's statement was voluntary, and if the statement was given in custody, whether that defendant was properly advised of his or her constitutional rights. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you may also consider to what extent a defendant was informed of his or her rights as discussed below, if applicable. You may consider the legality, duration, and conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made. However, under the law, in order for a statement to be excluded because of illegal detention, it must be shown that the statement was, in fact, induced by such illegal detention. The burden of proof is upon the state to establish that the statement was voluntary. That is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether a defendant was advised of his or her constitutional rights and whether a defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that a defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. 1, a defendant has a right to remain silent. 2, if a defendant chose not to remain silent, anything he or she said could be used as evidence against the defendant in court. 3, a defendant has a right to consult a lawyer before any questioning and to have the lawyer present with him or her at all times during any questions. And 4, If a defendant did not have money for a lawyer would have been provided for him or her to represent him or her before any questioning and to be present with him or her during any questioning. If a defendant exercises any of these rights, such as requesting an attorney, the police cannot question the defendant any further without an attorney being present. If the police initiate or continue conversation with a defendant after the defendant exercises such right, then any statement made to the police by that defendant after he or she exercises such right would not be voluntary and would be in violation of the defendant's rights, and you must disregard it entirely and completely in reaching your verdict in this case. However, if a defendant solely on his or her own initiative, after exercising such rights, freely and voluntarily requests and initiates further conversation with the police without an attorney and without any request, instigation, coercion, duress, fear, or hope of benefit or reward, or other action on the part of the police, then you would be authorized to consider it, provided you find from the evidence and the court's instructions that any such conversation or statement was otherwise freely and voluntarily given by the defendant. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given, that they were understood and knowingly given up by a defendant. If you find, as mentioned above, the defendant's statement was voluntary and that all other warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find a defendant was properly informed of these rights and that he or she understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict. You should consider with great caution any alleged confession a defendant made outside of court. You may believe none, part, or all of it. You should apply the general rules for testing the credibility of witnesses in deciding whether to believe any or all of a confession and in deciding how much weight, if any, to give that confession. A defendant's out-of-court confession that is not supported by any other evidence is not itself sufficient to convict, even if you believe the unsupported confession. However, no specific manner of corroboration of the defendant's confession is required, and corroboration of any part of the confession may be sufficient. If you find that a defendant made a confession and that it was supported by other evidence, then you must decide whether the confession, along with all the other evidence, proves that a defendant's guilt beyond a reasonable doubt. One second, can I have the attorneys to approach?
ladies and gentlemen. Evidence of prior difficulties or lack thereof between the defendant and the alleged victim has been admitted for the sole purpose of illustrating, if it does, the state of feeling between the defendant and the alleged victim. The reasonableness of any alleged fears by a defendant or alleged victim. Whether this evidence illustrates such matters is a matter solely for you, the jury, to determine, but you are not to consider such evidence for any other purpose. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged to you regarding credibility of witnesses. Some, but not all, of the factors you may consider in assessing reliability of identification are, number one, the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident. 2, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident. 3, the possibility of mistaken identity. 4, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have. 5, whether the witness on any prior occasion did not identify a defendant, in this case, as the alleged perpetrator. And 6, the length of the time between the crime and the out-of-court identification. It is for you to say whether, under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify each defendant beyond a reasonable doubt as the perpetrator or perpetrators of the alleged crimes, or that either or both defendants were a party to it. It is not necessary that a defendant show that another person committed the alleged offenses. If you do not believe that a defendant has been sufficiently identified as the person who committed the alleged crime or was a party to it, or if you have any reasonable doubt about such, then it would be your duty to acquit that defendant. The burden of proof rests upon the state to prove, beyond a reasonable doubt, the identity of the defendants as the person or persons who committed the crime alleged in this bill of indictment. Each defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. When a count of an indictment charges that a defendant committed a crime in more than one way, you may convict him or her if the evidence shows that the crime was committed in any one of the ways charged. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such inference is a matter solely within your discretion. Both defendants will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the products of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, intentionally advises, encourages, hires, counsels, or procures another to commit the crime, or intentionally causes some other person to commit the crime under such circumstances that the other person is not guilty of any crime, either in fact or because of legal incapacity. Knowledge on the part of a defendant that the crime of malice murder, felony murder, aggravated assault, family violence, or concealing the death of another was being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case the defendant had no knowledge that a crime was being committed, or that the defendant did not knowingly and intentionally commit, participate, or help in the commission of, and was not a conspirator in the alleged offense, then it would be your duty to acquit that defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of malice murder, felony murder, aggravated assault, family violence, or concealing the death of another was being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict that defendant. A jury is not authorized to find a person who was merely present at the scene of the commission of a crime at the time of his perpetration, guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. A jury is not authorized to find a person who was merely associated with other persons involved in the commission of a crime, guilty of consent in or concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. The law provides that criminal actions shall be tried and indicted in the county in which the crime was committed, except as otherwise provided by law. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Richmond County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence, or both. Criminal homicide shall be considered as having been committed in the county in which the cause of death was inflicted. If it cannot be determined in which county the cause of death was inflicted, venue is proper and may be proved in the county in which the death occurred. If a dead body is discovered in this state and it cannot be readily determined in what county the cause of death was inflicted, venue is proper and may be proved in the county in which the dead body was discovered. A person commits conspiracy to commit a crime when that person, together with one or more other persons, conspires to commit any crime, and any one or more of such persons does any overt act to bring about the object of the conspiracy. A conspiracy is an agreement between two or more persons to do an unlawful act, and the existence of a conspiracy may be established by proof of acts and conduct, as well as by proof of an express agreement. When persons associate themselves in an unlawful enterprise, any act done by any party to the conspiracy to further the unlawful enterprise is considered to be the act of all the conspirators. However, each person is responsible for the acts of others only insofar as such acts are naturally or necessarily done to further the conspiracy. Whether or not a conspiracy existed in this case is a matter for you to determine. Presence, companionship, and conduct before and after the commission of the alleged offense may be considered by you in determining whether or not such circumstances, if any, give rise to an inference of the existence of a conspiracy. For malice murder, the state must prove that a defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the lawful intent to kill. You may find malice when the circumstances show that a defendant acted with a deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be sufficient provocation, and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in a defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice or forethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining either defendant's state of mind at the time of the killing. For felony murder, the state must prove that a defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault is a felony, which I will define for you shortly. You may find the defendant guilty of felony murder if you believe that he or she caused the death of another person by committing a felony of aggravated assault, regardless of whether he or she intended the death to occur. There must be some causal connection between the death and between the felony and the death. Felony murder is not established simply because the death occurred at the time or as shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. For aggravated assault, the state must prove that a defendant assaulted another person with a deadly weapon or with an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that a defendant attempted to cause a violent injury to the person, committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. An offensive weapon is any object that is likely to cause, or actually does cause, death or serious bodily injury if used against someone. In deciding whether an unknown object is a deadly weapon, you may consider all of the following factors: the nature and extent of an injury inflicted, the character or capabilities of the weapon, the manner in which it was used, any display of it to the jury, any other circumstance of the case. For concealing the death of another, the state must prove that a defendant concealed the death of another person, which hindered the discovery of whether that person was unlawfully killed. By no ruling or comment that the court has made during the progress of the trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of either defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against either party. You are only concerned with the guilt or innocence of the defendants. You are not to concern yourself with punishment. One of your first duties in the jury room will be to choose one of you to be the foreperson. Start again. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign a verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, You must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Though you may consider all of the evidence as a whole, conviction of one defendant does not necessarily require conviction of another or all. You, the jury, must determine the guilt or innocence of each defendant separately. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that either defendant in Richmond County, Georgia, did on or about April 17, 2017 to May 23, 2017, commit the offenses of malice murder, felony murder, aggravated assault, family violence, or concealing the death of another as alleged in the indictment, you would be authorized to find that defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that either defendant is guilty of any of these offenses, or if you have any reasonable doubt as to either defendant's guilt, then it would be your duty to acquit that defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. Whatever your verdict is, it must be unanimous. That is, agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. The following is the required procedure for, let me start again. The following is the required procedure for jury communication to the court from outside the courtroom. Any jury communication to the court must be in writing. Parties must be informed of the communication's content, and the writing must be marked as an exhibit and entered into the record. The court must allow counsel to suggest an appropriate response. The court must inform counsel of the court's intended response. The court must allow the opportunity for counsel to respond. Denise Pugh, raise your hand. Okay. Ebony Lindsay. All right. Besides the two jurors I just named, to the rest of the jury, you may now retire to the jury room. Wait 1 second before we do that. You're going to have two separate jury verdict forms for each defendant. And it's pretty simple. As in count one, malice murder, you are to circle whatever your decision is. If you determine that defendant Tanya Tripp on malice murder is not guilty, then you would circle that and go down the rest of the form making your decisions. The same would apply to defendant Leon Tripp. If you were to decide on either one of the counts, guilty or not guilty, you would just circle your decision on that count. You may now retire to the jury room, but do not begin your deliberations until you receive the indictment and any evidence that has been admitted in the case. Also, you will receive, as I told you earlier, a copy of the charge. Bailiff, will you please escort the jury to the jury?
All rise for the jury.
Be seated, please. Ms. Pugh and Ms. Lindsay, you two are alternates on the jury. The law does not allow you to deliberate with the original 12 jury members. However, we can't release you. We're gonna have you to stay with us in a separate room, just in case, for whatever reason, a juror can no longer serve. One of you would then be called to deliberate with the other 12 jurors. So at this time, bailiff is going to take you to that room. Rise. Be seated, please. All right. Counsel.
I don't think I charged them as to family violence.
You did, Judge.
I did? Was that a part of the charge? Aggravated assault, family violence?
Part of the aggravated assault.
I read aggravated assault, but I don't know if it mentions anything concerning family violence.
Yeah, there's another section in the aggravated assault, and I may not have even listed that.
When I was reading, it just came to mind that they're not.
Yeah, in the pattern of charges, there is additional language in there that says, in order for it to be family violence, you have to determine whether or not.
So I think we got to charge them on that.
We do, Judge. Whatever the pattern of charge language is, it's fine with me. It's in the pattern.
All right. You pulled it?
I'm cool.
She pulled it now, all right. So we're gonna have to bring them back in and charge them on that.
But if we want to go ahead and do the evidence, make sure.
Yes, we can go ahead and do that. And, right, any exception to the court's charge as of right now by the state?
No, Your
Ms. Stengel on behalf of Mr. Tripp?
No, Your Honor.
Mr. Reagan on behalf of Mrs. Tripp?
Yes, Your Honor.
Okay,
As discussed earlier, the charge of conspiracy.
all right. Noted for the record. I want to say at this time too, I was very impressed with counsel during the trial of the case. The closing arguments were outstanding as to each counsel, and you did a great job. We're gonna have to bring them back, not right now, we need to give them one additional charge as soon as we get it pulled up.
All right.
This is the third section. Oh, yeah. There is this,
Yeah, there.
And the city's open.
Sims. Sims is a four-person.
You direct us.
Okay, all right. Right. Okay. Is she, Shatara Sheriff Sims. Shatara Sims is the four-person.
What's the name?
Sims number 4.
I'm just teasing.
I don't see anything in pattern, that's a confining thing, so.
I think it's with the language in battery, family violence.
I was gonna say, I think this we got.
It's in battery, family violence.
No, you're fine, I was just.
They're not. And then we would also do. This picture, and then the ring, the bra.
So we don't see anything in any of the, pattern charges, but I think we just need to charge them on the statute.
It may have been one of those ones where I had to create one before I thought it was in the pattern very short.
There's how it's like family cruelty to children, but not assault and battery itself.
Sims.
I mean, as long as you follow the statute language, you're never gonna do it. I've learned that the hard way.
So any objection just to charge OCGA 1913-1 family violence fine?
Yes.
Mr. Race?
No, promise you can listen.
No, you're fine.
Yeah, I mean, what was the question, Your Honor?
We did not define family violence in the charge on aggravated assault.
I have no objection, Your Honor. But at the appropriate time, we'll object to a couple of items going back to the jury.
Okay, and we could probably handle this real quickly before they come back out.
Do you want me to print that to add into the copies, or like just the words?
Yes.
Is it the CAD and the calendars?
Yeah.
I'm not objecting to the calendars, yes.
Okay.
You want to do that now, Mr. Rakes?
Yes, we can go ahead and handle it.
I think that would be an efficient way to handle it. Of course, I trust everybody else's judgment.
Right.
Well, I'm objecting to State's Exhibit 44 and State's Exhibit 45 going back with the jury as a continuing witness. These are calendars that were blank, but as a witness would testify about an event, the state would write down that event on that particular day, almost copying the testimony from that witness onto the blank, well, formerly blank spot. So I'm asking, and that's the same with State's Exhibit 44 and 45. They are both written down, the written testimony of certain witnesses as to events on certain days. And I'm objecting to these going back with the jury as continuing evidence, Your Honor.
State's response?
And Judge, I'll just say, I mean, they're not really testimonial in nature. Typically, when we leave evidence out, for example, we're leaving out both of the narratives from the GBI and the Dr. NT. That's simply a calendar with dates and certain events that have happened throughout. Not really testimony in nature, but whatever the court decides.
Well, just as an abundance of caution, I think we just don't send it back. And of course, if they want to see it, they're entitled to see it. If they, you do agree to that, Mr. Rakes, that if they want to see it, they are allowed to see it?
I object to that as well. That would be, I guess, that would be the equivalent of going back and rereading testimony. But I just object as they would put additional weight on that if it were to be pulled out and read to them separately. I'd ask it stay out altogether.
And they're demonstrative in nature, so if the jury wants to come back out and look at them.
I think they can come back out and look at it.
Come back and look at it. Just like they can watch a video, just like they can read that report if they want to.
So I won't send it out with the jury, but if they ask to see it, I will allow them to see it.
That's fine.
Thank you, Your Honor.
Yeah. And I'll note your exception to them seeing it at all, right, Mr.
Yes.
All right.
Where do I put these?
Maybe with the CDs, because they're not going out.
I'm not too sure. I don't know.
And you're fine with the cat?
Yes, I am.
And then you're fine with the pictures and the system?
Yes. I am. I can't.
I think they were fine.
Yeah.
Just an aggravated assault.
So on this charge, do y'all believe I need to charge on aggravated assault again and then read the family violence part, or just charge them on the family violence?
I'm fine with you just saying, this charge is in reference to the aggravated assault that you've already previously been given. But if you feel like we need to reread the whole thing, I'm fine with that too.
I agree with your proposal.
No objection.
All right.
I'm just titling it for purposes of the other ones, family violence. And then in the statute, it says, as a documents article, the term family violence means. I'm just starting at the term family violence means, if that's.
That's fine. And Chris, you know we have to bring the alternates back to you, right?
Just go at the end.
I was going to play.
Yeah.
That's kind of what
Because the jury doesn't need the charge.
I'll add it.
Then alternates that way. But we'll get a line up.
Oh, yeah. Your Honor, can I approach on an unrelated matter?
2 weeks.
Yes, ma'am.
So I wanted to spend 2 weeks on my life on this, I'll have to come back to you again.
I don't blame you there.
Technicalities.
Not to mention.
Good afternoon, Your Honor.
How you doing, sir?
All good, sir. How you doing?
All right.
Jerry just. He can't.
I got called into like,
More money.
a gym on here
Remember you come in one time, you was,
Master's polo
Yeah.
and slacks. I think I was like the only person here, and they had like emergency on here.
I knew you had to come in for something one time, you was just in plain clothes.
I was like,
Judge Craig, what, something?
I did this Craig or something.
I can't remember. He said, who cares?
Thank you, Jared.
Thank you. Are we ready for the jury?
Yeah, yes, Your Honor.
All right. Before they bring them in, do we, I'm just looking at, do we need to give that whole charge or just any felony?
I would say any felony at this point, they didn't request any, lesser included, or anything, so I think just any felony.
I agree.
So we need to take that.
I'll take that.
Sorry, what was the court's ruling?
The misdemeanor references in the statute, we're gonna delete those.
Okay.
So we can bring them in and I just won't read that.
Do you guys want copies of it without that, or are you fine?
I'm fine.
I'm fine.
Okay.
Thank you. As long as they get the one redacted.
Yeah.
Yeah, I got it.
Sam actually did it. Connor and Asher were like 168, 167. Big old tear. It's like putting the hammer on his face.
All eyes on Jerry, please.
Be seated, please. Ladies and gentlemen, I neglected to charge you on the definition of family violence. When I was reading the instructions, I realized I had left that out, so I'm gonna give you this, this definition of family violence that you're to consider with the rest of the charge that I had given you. You shouldn't give this, instruction any more weight than the other instruction you were given. This is just one that I neglected to give you when I just gave you your charge. The term family violence means the occurrence of one or more of the following acts between past or present spouses, persons who are parents of the same child, parents and children, step-parents and stepchildren, foster parents and foster children, or other persons living or formerly living in the same household. And any felony. The term, hold on a second. council approach. And then, all right, let me read that to you again. The term family violence means the occurrence of one or more of the following acts between past or present
spouses, persons who are parents of the same child, parents and children, step-parents and stepchildren, foster parents and foster children, or other persons living or formerly living in the same household, and the commission of any felony. The term family violence shall not be deemed to include reasonable discipline administered by a parent to a child in the form of corporal punishment, restraint, or detention. All right, at this time, ladies and gentlemen, you can retire back to the jury room. Of course, alternates, you are to retire back in the room that you are in, and we will be soon bringing to you the indictment, the verdict form, the court's charge, and the evidence. And once all that is received, you may begin deliberating.
All right, secure, please.
Be seated, please. Any exception to the charge regarding the definition of family violence by the state? Ms. Stengel?
No, Your Honor.
Mr. Regis?
No, Your Honor.
All right, thank you very much. I'll give you all the verdict forms, the indictment.
Yeah, I know. Just making sure that this is leave it at the top. How about you?
That and all that.
Is the charge ready for them?
Adding.
Oh, okay. Yes, we are in research, we're awaiting the verdict of the jury.
right after, so the show is about 3 hours, it starts at 8, so I'm hoping that like when I walk back to the hotel, we'll hit it. So you get to watch all the English.
Yeah. Good admin, all that stuff on the shop. Simple work.
Yeah.
I'm 7 hours.
All right, jury, please.
Probably not.
All right, be seated, please. Ladies and gentlemen, I am going to excuse you for the rest of the day. I have an obligation myself, and it's been a long day for y'all. I know it has been, and it's also been a long day for these lawyers. And so I think it's in everybody's best interest that y'all go home and get some rest. I ain't tired. You know, I can stay here till this time tomorrow if y'all want to do that now. Do y'all want to do that? And just let me know. We can spend the night. Oh, okay, all right. So y'all know what I'm getting ready to do now, right? Yeah. All right. Please do not watch any news accounts of any sort. Please, the best you can, to stay away from any social media, any type of social media platforms. Please don't watch any news accounts on television or on your phones. Please don't listen to any news accounts. Please don't read any news accounts about this case. Please don't go out and do any research about the case. Don't try to visit any scene location. Don't go to any reference material about the case. Don't try to find out anything any more than you have learned the last 5 days or whatever it's been since we've been trying this case. I guess it's been 6 days, I guess. Don't use your phone. Don't use your laptops. Don't use tablets. Don't use any notebooks to try to find out anything about this case whatsoever. Don't let anybody talk to you about this case, even when you get home. I know that you probably got folk at home who curious to know what you know and know what you're thinking and that type of thing. Please don't discuss it with friends or family, anything about this case. You've been deliberating in your jury room. That's where your deliberations should take place. Please don't talk amongst yourselves about the case. And as always in ending, if anybody tries to approach you for any reason about this case, please notify the bailiffs immediately so we can check into that situation. So no blogs, no websites, no electronic tools. Clear your mind because you're tired anyway. So just rest, just get some rest and if you can be back here, will y'all bring them straight up to the jury room at 9 o'clock? Yeah. Yes. Yeah. So they need to report downstairs and y'all will just bring them up. Somebody will be down in the jury room at 9 o'clock, so you report to the jury assembly room, downstairs, jury assembly room at 9, and then the bailiffs will bring you up at 9, or as soon as everybody's here, so that y'all can go back and begin your deliberations. All right? And with that, and of course, alternates, this applies to the alternates also. All right? So with that, have a good evening. Be seated. All right, anything from the state?
Not from the state, sir.
All right, Ms. Stengel,
No, Your Honor.
Ms. Regis? All right. With that, we'll be in recess, y'all said 9:15, is that what you said, or 9?
Do you want us in? Want
I
to
mean-
check in here, or should we just be in the building?
I was just, in the building is fine with me.
I'll be here at 9:15. I got nowhere else to go.
They do have a lawyer.
Yeah, so, yeah, it's down there near, right, when you go to the clerk's office to the left.
Hey, you have to talk to Mr. Davis about that, man. I actually didn't know about it until I actually came back.
Kevin never told me this in our meeting.
But do y'all want to make it 9:30? Y'all think? I was 9:30.
If the jury's gonna be here at 9, I'll be around here. a little
Right.
bit, just in case.
Okay, I was at 9:30, that should be fine.
Thank you, Your Honor.
All right?
I'm sorry. Thank you.
Some steakhouse at Sunbury near downtown. Oh, and I would send it to you, but I don't think I locked your room. I have to look for
You're all good.
American.